questions, and each member has 5 minutes. I'm going to try to ask 2 questions to clarify, I think, 2 important issues. And I'm going to start with you, Ms. Sullivan. And I want to go to this preamble question. Professor Foley noted Article 5 in her presentation to the committee. I looked at Article 5. There is no mention of the word preamble in Article 5. I look, of course, to the preamble to the Constitution, and as memorable as the words may be, I don't believe that they have driven decisions of the court or at any stage. The body of the Constitution does over and over again. I can't recall, maybe I'm just not aware of it. The preamble has been a driving force to establish or to question a person's rights. And, of course, this Constitution in Article 7 spells out exactly what ratification of the Constitution entails. And again, we have an important paragraph which does not include the word preamble at any stage. So my question to you initially is, the argument that this is in the preamble and should be treated differently than other places, you've stated already. But what is your comment on the preamble to the Constitution and the fact that it has not been a driving force?
Preambles can have eloquent power. The preamble to the Constitution is perhaps the greatest preamble ever written. But preambles do not drive the interpretation of Article 5 joint resolutions, and they never did, and no court has ever declared it. And crucially, I want to focus on Dillon versus Gloss, which Senator Graham mentioned earlier, 1921 decision that, of course, did hold that the 18th Amendment was not unconstitutional by virtue of the 7-year expiration date that was baked into it and ratified by the states. That, crucially, was not a preamble. It was the language, the 7-year deadline was an expiration date in the text. Now, why does that matter? It matters because the states vote on the text of the amendment. When they ratify, the states are not ratifying the preamble, they are ratifying the text. So it's one thing to bake the deadline into the constitutional text and have the states vote on it. That might be binding. But a preamble is just advisory. It's your dialogue with the state saying, get this done in 7 years, but maybe we'll revisit it. And if anything, the language of Coleman versus Miller, the 1939 case, is supportive of the view that the Congress does have the power now to say we think the ERA is still vital and we think we should remove the prior deadline. One Congress can't entrench itself into the future by binding a future Congress. One Congress can't prevent the states from exercising their ratification role by setting a binding deadline on the states enforceable by a court. So there's no constitutional decision by the Supreme Court standing in your way. Dillon versus Gloss is inapposite because it was about a deadline in the text and not the preamble, and Coleman versus Miller is supportive of this Congress's role in deciding that the ERA still has a vital role to play today.
So let me go to a second question that was raised by Professor Foley as well as by Senator Graham. Since Congress sent the resolution proposing inclusion of the ERA in the Constitution to the states in March of '72, as we know, 38 states have ratified the amendment. However, 5 of those states have subsequently sought to rescind their ratification. Nebraska, 1973, Tennessee, 74, Idaho, 77, Kentucky, 78, and South Dakota in 79. North Dakota also recently voted to rescind its ratification in 2021. What is the legal significance, Ms. Sullivan, of these state legislatures voting to rescind their ratifications?
It has a state rescission has no force under the text of Article 5, which speaks of ratification and not of rescission. Number 2, when 2 states tried to withdraw or rescind their ratification of the 14th Amendment after it was proposed and adopted, this body rejected that. So there's precedent in this body for rejecting efforts to rescind. And to the extent this body has the power I described before, this body has the power to affirm that those rescissions are ineffective now, just as they were for the 14th Amendment. We wouldn't have had the 14th Amendment today if we'd listened to rescissions.
Thank you very much. Senator Graham. Thank you, Mr. Lindley. We'll start the questioning. I want to thank you personally. 27 years in law enforcement, and I want to thank all the men and women in law enforcement. We know that they are under close scrutiny and living lives which subject them to dangerous situations on a daily basis. to protect us, our neighborhoods, and our homes. But let me ask you this point blank. We're in mourning in Chicago because 2 weeks ago today, an officer responded to a domestic violence incident, came across a man with a gun, chased that man, who turned on him and killed him in a playground of a school in Chicago while the children around were cringing in fear. How often do domestic violence incidents, have you run into domestic violence incidents in your practice of law enforcement?
Thank you for the question. Law enforcement is one of the most difficult jobs I think we have in this nation. We ask a lot of our officers day in and day out. And one of the most unpredictable situations that they're called to deal with is domestic violence. They're going into a charged, emotionally charged situation, not knowing what the basis of it is into a situation that may have taken years to come about. Also, you look at the different type of weapons inside the house. You have firearms, you have bats, you have knives, you have frying pans. It is a very difficult situation, and lots of injuries to law enforcement and injuries to the public come about from domestic violence situations.
So one of the witnesses here says, well, it's okay, Rahimi, if you accept it, that person would have a gun, they'll probably break some other law that they can be prosecuted. Does the presence of a firearm in a domestic violence dispute make it more dangerous for the police?
Absolutely. Firearms in the house when law enforcement is there in an emotionally charged situation, unless the situation is completely controlled, which is difficult for law enforcement to do these days, makes it very dangerous for them.
Professor Rubin, let's follow what the court has decided and see if you can help me understand it a little better. They've decided that they can't find, and Rahimi, they decided they couldn't find an analogy to removing a firearm from a person who was under a domestic violence protective order. And so as a consequence, they struck down the applicable law in that situation. And yet when it comes to the firearms themselves, they don't go back to 1791 and ask the obvious question. What did the founding fathers have in mind when they used the word arms? They seem to have expanded to almost anything. I used the example before in Highland Park at a 4th of July parade with a man on the roof of a building firing off 83 rounds in 60 seconds, killing 7 people, injuring dozens of others. There wasn't even a weapon imaginable in 1791 that could do that. How do they make that leap when it comes to arms to include that type of assault weapon?
Thank you, Senator. So this is one of the challenges and the questions that comes up after Bruin is how can we make sense of our historical gun laws in light of the vast changes, including gun technology and also in terms of our moral sensibilities. We had a blinkered moral sensibilities when it came to gendered violence back in 1791. And one of the points that I flesh out a bit in my written testimony is that if we're going to be approaching what counts as an arm at a high level of generality and allow that to evolve with the times, then we certainly need to find ways to likewise allow our regulatory frameworks to evolve as well to deal with modern problems today.
Ms. Glenn, you have a personal experience with this, which is chilling to think what you went through as a victim of domestic violence. What do you think about the argument that someone with a gun in a domestic violence episode is likely to break some other law that they can be prosecuted for, and that's good enough?
Thank you so much for the question. It certainly is not good enough. Without understanding the dynamics of domestic violence and when there is a domestic violence situation in which an abuser has a firearm and the escalation that occurs, and if you don't understand the dynamics of domestic violence, sometimes that's all that's present is the domestic violence situation. Waiting for prosecution or charging in that particular instance is unreasonable. Protective orders are built to help the victim provide themselves with protection. Removing the firearm is also that part of ensuring that safety and that they can be safe.
Thank you. Senator Graham.
Upon which our department was founded is needed now more than ever to address the challenges we face. Thank you very much. I look forward to your questions.
Thanks, Mr. Secretary. Let me start my questioning where Senator Graham left off. We have a bipartisan concern about fentanyl in the United States. As Senator Graham mentioned, 70,000 fatal overdoses in the U.S. every year. We need to launch, the President says we need to launch a major surge to stop fentanyl production and sale. I'd like to start at the obvious place. Where is it coming from? Well, it may start with precursor chemicals in China, but it certainly comes through the two major drug cartels in Mexico, which are the major exporters into the United States, Jalisco and Sinaloa. Here's what the former Mexican ambassador to the United States, Arturo Surcan, said. Mr. Surcan said only a handful of law enforcement agencies in Mexico are willing or able to engage with the powerful drug gangs. Quote, "There's no doubt that endemic corruption, impunity, a weak rule of law are Mexico's Achilles heels." He went on to say that means fentanyl and methamphetamine labs operate in Mexico with almost no pressure. I've had two lengthy conversations with Ann Milgram with the Drug Enforcement Administration about this challenge of fentanyl. I will say, I want to mention to my colleague, Senator Graham, and others on the committee, when we get into the world of social media in a couple weeks in this committee, one of the first stops will be Snapchat for me, because according to DEA, this is the major clearinghouse for the sale of fentanyl in the United States, these fake drugs that are being sold. So my question to you is not easily answered and maybe impossible to answer. Tell me how we strike a relationship with Mexico to actively cooperate in the flow of individuals who are coming toward the United States, while at the same time deal with the reality that they are failing miserably when it comes to the export of deadly narcotics to our country.
Mr. Chairman, you and Ranking Member Graham accurately describe the cartels as vicious, ruthless organizations that peddle in the death of individuals, including tens of thousands of Americans. We in the Department of Homeland Security are taking it to the cartels and the smuggling organizations with which they work in unprecedented fashion. And you noted, as did I, Operation Blue Lotus, the most recent surge of personnel and other resources and intelligence to take it to those cartels. We're seizing more fentanyl at our ports of entry than ever before. We in the Department of Homeland Security, through Homeland Security investigations, the criminal investigative arm of Immigration and Customs Enforcement, are working with our Mexican counterparts on an increasing level. We have transnational criminal investigative units that have indeed disrupted laboratories that manufacture fentanyl, that have helped interdict the flow of fentanyl within Mexico, that have in fact cut off financial streams, but the battle is very difficult, and we are seeking to cooperate more closely with our Mexican counterpart, and we're doing so in an all-of-administration effort, not just the Department of Homeland Security, not just the Department of Justice, of which the DEA is a part, but across the entire administration.
So let me ask you about the effort we're making. A lot of publicity has come out with the notion that people seeking asylum or refugee status are really transporting fentanyl into the United States. The chart which I demonstrated earlier suggests that 80% or more is actually coming from American citizens crossing at ports of entry. If we eliminated every applicant for asylum or refugee status, we would still have a tremendous flow of deadly narcotics coming in across the border. Is it impossible for us in this day and age to stop this flow by ordinary legal Americans through our ports of entry of narcotics?
Mr. Chairman, we are working intensely to devote additional resources to the ports of entry on the land of our southern border. That is where more than 90% of the fentanyl is transported through passenger vehicles, through trucks, by pedestrians that are lawfully coming into the United States through the ports of entry. We are surging resources to the ports of entry to battle that. We are seeking more resources in our fiscal year 2024 budget for precisely that purpose, to add personnel, to add non-intrusive inspection technology, to allow our forward operating labs to detect the substance at the point of interdiction so we can bring our investigative and prosecutive capabilities right there and develop the force that we need to.
To put some perspective on this, it's my understanding that a backpack full of fentanyl is dangerous to thousands of people if it makes it into the United States. And we are talking about transport trucks flowing across our border by the thousands every single day. Does there exist technology to detect this fentanyl in these carriers coming into the United States?
There is, Mr. Chairman. It is called non-intrusive inspection technology. We are investing more in that. In addition, we are exploring how we can use artificial intelligence to really serve as a force multiplier of our incredible Border Patrol agents and our incredible Office of Field Operations officers who do such heroic work in this regard.
So we put some more money on the table for you when it comes to this technology. How much more do you need?
We are seeking we're seeking hundreds of millions of dollars for non-intrusive inspection technology in our fiscal year 2024 budget. We are also seeking to plus up our personnel, both our officers in Office of Field Operations and our Border Patrol agents.
Well, I certainly hope we have bipartisan support for that when it comes before the Senate and the House of Representatives. There was one aspect of your opening statement which you noted in summary before us that caught my eye, and that was the issue of drones. Would you please explain why that has become a new and concerning threat to you?
Mr. Chairman, the technology has advanced so significantly in the area of drones, as it has in so many different areas. These drones can fly farther, faster, have greater visibility, carry heavier loads, and they are being used by individuals with nefarious intent, as well as by adverse nation states, and we need to have the capability to counter the use of drones. They invade our airspace. They hover over public gatherings with bad intent. We have got to be able to counter them. We have the authority now. It sunsets. We need to renew it. And also, Mr. Chairman, we need to expand it.
Well, I'm certainly open to that, as I think many of my colleagues are. So let's work on that issue as well. I was briefed 2 or 3 weeks ago on artificial intelligence. It was a frightening presentation when you consider the opportunities of AI to overcome what we think are protections in cybersecurity. You mentioned artificial intelligence in your opening statement. Can you comment on the challenge it's going to create for us?
Mr. Chairman, I am tasking the Homeland Security Advisory Council to provide advice to us in this regard. We, of course, are already focused on it, but want different perspectives. Artificial intelligence presents an opportunity for good that we seek to harness to really serve as a force multiplier in advancing the security of our country. At the same time, in the wrong hands, it can be a weapon. It could be a weapon of harm. And we have to build the defenses that are ready to secure the homeland with respect to the potential that AI presents.
Last point I'll make to you is that I have been meeting, as I told you in our phone conversation yesterday, with many of the immigrants who've come to the city of Chicago and sat down with them in conversation as to their backgrounds and why they came here. I will tell you, without exception, not a single one of them asked for the address of the local welfare office. Virtually every one of them asked me, where can I go to work? Now, we have this system of law that does not allow a person to legally work in the United States until a period of time has passed, 6 months to a year, once they're in here, even waiting for a determination of their refugee status. That creates a dilemma for many of these people who have no resources to live on. How do you answer critics who say we ought to give them an opportunity to work?
Mr. Chairman, the law provides that an individual can seek work authorization after their application for asylum has been pending for 150 days.
And of course, that can be lengthened, unfortunately, to longer periods of time as they're waiting for that determination. Isn't that true?
Yes, that is true, and we are climbing out of a backlog because U.S. Citizenship and Immigration Services, the agency that issues the work authorizations, was financially devastated in the prior administration. It is funded primarily through fees. Every 2 years, it is to issue a new fee rule that calibrates the cost of immigration benefits according to the cost of operationalizing their administration. A fee rule has not been issued for more than 6 years, and we have a pending proposed rule now to really readjust, realign the costs of immigration benefits to the cost of the agency to administer them.
Thank you, Mr. Secretary. Senator Graham.
Thank you. The maxim.
To speak on a separate topic and that it be placed in a separate part of the record.
Without objection.
Mr. President, you were there yesterday. The Senate Judiciary Committee met. I chair that committee, and we had a strong turnout of Democrats and Republicans to consider an issue which everyone's read about or heard about over the last several weeks, and that is the ethical standards applied at the highest court in the land, the United States Supreme Court across the street. We've all read the news stories that led to this hearing. Questions raised about one particular justice, but not him alone, in terms of gifts that they've received and whether it influences their decision-making on the court. That is basic and fundamental. If you think the fix is in on a court, you don't have much respect for their operation. So the question is, what's going on in the Supreme Court? And as it turns out, as you well know, we have ethical standards all across the federal government that apply to the members of the Senate and the House, the executive branch, and to all of the courts below the Supreme Court in terms of financial disclosure and basic rules of the road of what you can do and what you can't do. For example, there's a basic standard that is used for gifts for members of the Senate and House that puts a limit of $50 on the value of any gift. I have returned gifts given to me, which I thought exceeded that value. I'm sure the presiding officer has as well. But that's our standard. There's no such standard, as best we can understand, when it comes to the Supreme Court, the highest court in the land. So it turns out the highest court in the land has some of the lowest ethical standards. Why? Well, when this came to light in the news articles about Justice Thomas, I wrote to the Chief Justice of the Supreme Court, John Roberts, and invited him to come to the hearing yesterday to tell his side of the story. What is the Supreme Court doing when it comes to ethical standards? They don't play by the same rules as all the other courts in America. What are their standards? Well, the Chief Justice declined my invitation and sent along some documents to indicate what he thinks are the rules of the road for ethics in the Supreme Court now. They were interesting, but unfortunately, they revealed that the standards at the highest court in the land are not even equal to the standards at all the other federal courts. So we had a hearing yesterday on the subject, and we invited witnesses from the Republican side and the Democratic side to comment on the current state of affairs. If the Chief Justice couldn't appear or would not appear, we went forward with the investigation, which is our responsibility under the law. Now, asking a justice of the Supreme Court to come and testify before a congressional committee is not unusual. 92 appearances have been made by justices on the Supreme Court since 1960 before the committees of Congress. But yesterday, the Chief Justice, nor any other member of the justice on the Supreme Court, appeared before us. So what we found was a surprise to me. I thought there would be some bipartisanship to this, because in not too distant past, 2 senators on the committee had crafted an ethics bill on the disclosure of stock holdings, sent it not only to the president to sign, but it was embraced as well by the Supreme Court. A bipartisan, thoughtful measure for sure. But yesterday, I'm afraid things were very partisan. First, there was a question as to whether or not this was an attempt to attack the conservative members of the Supreme Court by raising ethical questions. I tried to make a point several times that the first letter that I sent to a Chief Justice, this Chief Justice, on the issue of Code of Ethics for the Supreme Court, I delivered on February the 13th, 2012, during the Obama administration. So this was not some newfound interest. I've been working on it for years. My colleague, Senator Sheldon Whitehouse, also has dedicated a major part of his Senate career to this issue of ethical standards before the Supreme Court. So the notion that we just invented this because of unhappiness with a recent court decision just doesn't hold up. Many of us have been working on this issue for years before any of these decisions were handed down. There was also an argument that Congress has no authority to establish standards for the Supreme Court. As I mentioned earlier, when we had the stock disclosure law passed last year, it was embraced by the court. The court goes through some form of financial disclosure based on a law passed in 1978. And by and large, there are many ways that the Congress interfaces with the Supreme Court, not the least of which is its budget. So we're in constant communication with the court and its operation. I believe that we clearly have the authority to establish ethical standards in law for the Supreme Court. The Republicans, to a person, disagreed with it. We also had an argument made that somehow we had singled out Clarence Thomas, a justice on the Supreme Court, and decided that he was going to be persecuted by this type of inquiry. Well, let me say the facts that were disclosed about his gift-taking from a Texas billionaire were extraordinary. I think they were a surprise to most people. Justice Thomas has not denied the fact that he took hundreds of thousands of dollars worth of vacations, yacht trips to Indonesia, private aircraft, from this Texas billionaire. He dismissed it and said that it was personal hospitality. Personal hospitality does not include transportation. And of course, this included a lot of the most luxurious transportation imaginable that the justice received. So to say that this was acceptable conduct, it clearly was to the Republicans yesterday, but I think most Americans want to know a little bit more about the relationship that would lead a justice to take hundreds of thousands of dollars worth of trip, not to mention that the same billionaire bought his mother's home and allowed her to live there afterwards. And so that was worth at least $140,000 to the benefit of the justice's family again. There were questions raised throughout as to why we would pick on one conservative justice. I will tell you the disclosures that have come out since the Thomas article about the gifts he's received from the Texas billionaire have included many members of the court, certainly those who wouldn't be put in the conservative category. Questions have been raised. Questions are raised about members of Congress all the time, and they should be. I know each year when I disclose my taxes and my net worth in detail, somebody's going to call with a question. Explain this item to me. Explain that item to me. That is part of the responsibility of public service. It's no fun, but it's part of the job. If you want to be a public figure, I think you owe it to the people to be assuring them at every step of the way that you're being honest about discharging your duties. So we haven't given up. When it comes to the Senate Judiciary Committee and the issue of ethics, we're far from finished. We had good testimony yesterday from witnesses that I think give us a basis for moving forward in this area. At the end of the day, we want to make sure that people, as skeptical as they are of politicians, they have every right to be, believe that the institutions, whether it's Congress or the Supreme Court or the President's office, are at least credible and trustworthy. Establishing a fundamental ethical standard that assures that fact is absolutely essential, and the Senate Judiciary Committee will continue that pursuit. Mr. President, I yield the floor and suggest the absence of a quorum.
Clerk will call a roll.
Ms. Baldwin.
Mr. Frost, each member will have 5 minutes to ask, and I'd like to start with you, Professor Frost. It's been stated, I'll say as a preface, that the reason for this hearing is that so many of us are unhappy with the decisions of the Supreme Court. I might state again for the record that my concern about ethical standards at the court predate this hearing by many years. In fact, 11 years. The first letter that I authored, which was signed by several colleagues on the subject to the Supreme Court, was mailed on February 13th, 2012. The president at the time, Barack Obama. So I wasn't waiting for this situation or any court decision to be interested in this issue. I think it was timely then and still is today. The second thing is the argument that we're out to get certain justices because they don't rule as we wish. I would have to say during the course of the public inquiry involving Justice Thomas and others, I've heard virtually every justice named with some question as to their conduct and activity. Now, some will say they were harmless activities and shouldn't be, no one should be punished for them, and they certainly wouldn't meet any high ethical standards. But I would just add that those of us who are in public service and bound by ethical standards and codes of ethics are certainly used to this experience. Every year when we file our financial disclosure forms, in my case, my income tax returns, I'm bound to have questions from the press, and I hope most of them are considered innocent but legitimate inquiries of a person in public service. Professor Frost, a man who submitted a letter for the record today, Judge Ludig, said of the issues that are before us, I quote him, "In complete agreement on Congress's indisputable constitutional power to legislate ethical standards of conduct that would be binding as to the non-judicial conduct and activities of the Supreme Court." You've heard arguments otherwise. I think page 12 of your testimony, which goes into one of the first acts of Congress, the Judiciary Act, belies this argument that somehow the Supreme Court is at a level where Congress can't address it. Would you comment on that?
Yes, and I'll also just note that I have been called to testify on this issue since 2006 and have been writing about it since 2005. So similarly to your point, this is not a new issue in response to recent decisions. So the separation of powers argument, I find confuses me because, of course, I think we all know from civics classes, separation of powers is, of course, a constitutional principle, which means that the branches should have some separate spheres of conduct and some separate roles in our Constitution. But checks and balances is equally important. And the role of the Congress is to establish the Supreme Court. It's not just permitted, it's required. The Supreme Court of the United States is constitutionally mandated under Article 3, but there is no detail about how it is to operate because that was left to the Congress of the United States under Article 1, Section 8, the Necessary and Proper Clause. And immediately Congress agreed to do that in the Judiciary Act of 1789, as it was required to do. The Congress sets the size of the Supreme Court. That is not in the hands of Chief Justice Roberts and his colleagues. Congress establishes the quorum requirement. That is not in the hands of Chief Justice Roberts and his colleagues. When this Congress passes a law that says that they must recuse themselves, the judges and justices of our federal judiciary, when there are certain conflicts of interest, the justices are not free to say, that law doesn't apply to me, I'm going to sit on that case anyway. And so what is troubling is there is an implication in the recent statement of policy, of ethics policies, as well as some previous statements by the court, that it doesn't think these laws bind it. And I find that very confusing in light of the text structure and long history of congressional administration of the courts.
Thank you. Judge McCasey, I'd like for you to address one issue. It appears to me that in the early days of our republic, an oath had a different meaning than it does today in this respect. It is, in the swearing in of members of Congress, for example, kind of a pro forma exercise. It would seem the words of an oath in the early days of the republic were taken much more seriously, so that when the Congress set out the oath for members of the Supreme Court, every judge and justice, quote, solemnly swear or affirm I will administer justice without respect to persons and do equal right of the poor and to the rich, and I will faithfully and impartially discharge and perform all of the duties incumbent on me. Those words were written not by the court, but by the Congress, enacted by the Congress. Don't you think that raises a question as to whether or not there is clear authority for Congress to put together laws that are as specific as this oath of office?
Respectfully, no, I don't. Prescribing the oath, which I recall taking when I became a district judge, is one thing. Prescribing the way in which the court administers its business and the way in which a court applies rules internally is something else. Part of the problem here is that no rule determines its own application. It always takes somebody to apply it, and the way the court functions internally is a matter to be left to the court. In particular, on recusal issues, the law that applies to recusal issues across the board for federal courts applies to Supreme Court justices as well. Their impartiality might reasonably be called into question, they're obligated to recuse themselves. That applies to district judges, it applies to circuit judges, it applies to Supreme Court justices. That is a law of general application throughout the judiciary. But when we're talking about internal administration in dealing with their practices and the way they administer their cases, I think that's an entirely different thing. So I recall taking the oath, but I don't think it means that Congress has the power to direct that the internal business of the Supreme Court be conducted in a particular way.
Thank you. Senator Graham.
Thank you, Mr. Chairman.
With my colleague, Senator Graham, about our experience on the Gang of Eight. Was that about 10 years ago?
Yeah.
We had 4 Democrats and 4 Republicans, and we spent months putting together a comprehensive immigration reform bill, which passed in the floor of the Senate. Included in that farm bill was a section on farm workers agreed to by both growers and farm workers, and it involved a path to citizenship. It was, I think, a thoughtful and serious attempt to address this problem. It passed in the Senate, was never called for consideration in the House of Representatives. Senator Bennett has been one of the leaders on this issue from Colorado, Senator Feinstein, Senator Rubio, and a few others. I do believe there is a will to solve this problem. And the fact that it is part of comprehensive immigration reform is the fact that we have, we think, valid arguments in many aspects of immigration to consider it. And I hope we do. I ultimately hope we do. I want to say that I have no prejudice against growers and farmers at all. I've had a valued member of my staff for many years who was whose family was one of the largest employers of migrant farm workers in Illinois, in southern Illinois. Good people, really thoughtful people who cared a lot for their workers, and they showed it. I also want to say that we're living in a world that is hard to understand. I pass by these fast food restaurants and I see what's written on the signs outside. Burger King, $15.70 an hour to start at your Burger King. You go by on I-55 driving from Chicago to Springfield, you pass an Aldi warehouse, Aldi, of course, being a major grocery company. They're offering nearly $20 an hour for starting salaries. For people who come to work for Aldi, I don't know what they'd be doing, but it certainly would not start off as being too technical. And they're being offered $20 an hour to sign up. So when we talk about the current wage rate in this country, I think we have to be honest and realistic about it. There's a competition going on and a bidding war for our limited number of workers. Having said that, Ms. Torres, I read your entire statement. You didn't have a chance in 5 minutes to present it. And there are many parts of it that are just heartbreaking to think in America that this is taking place. Would you address the issue of wage theft? That is in your statement there, and it appears that many workers who are nominally being paid so much per hour are actually being paid less because there's a middleman. What's that all about?
Well, thank you for your question, Senator. I'll begin this with a story from Georgia because I was just there last summer, and I was speaking with some farm worker women who are indigenous workers, spoke an indigenous language from Mexico. Their first language was not Spanish or English. And we were, they were walking through some of the issues that they're seeing and started to tell me that when they get paid, they're getting paid by the person who actually gives them a ride to work. So it's not the foreman, it's not the actual owner of the farm, and they're getting paid in cash. And they're very aware that often the wages that they're being paid in cash don't include the amount that they should be paid for the work that they did that week. And so we're looking at not just a foreman as an intermediary, now we're seeing this random person who's giving them a job keeping some of the money. And so these workers were letting me know that, well, we can't say anything, we don't have papers, and I need a ride to work because I don't own a car, I can't afford a car. And so we're talking about the most vulnerable of workers. When we're talking about individuals who are keeping our food secure, we're talking about individuals who often don't feel like they have a voice. They don't have legal status. They feel that if they say anything, they may get deported. And so,
let me add, if I can.
Of course.
Just a few weeks ago, it was disclosed about the exploitation of child labor, immigrant child labor. And some of that's happening in the heart of the Midwest. You know, I'm not going to name names for the states that are involved, but we think that we're above that sort of thing, and it's not true. In food processing and slaughterhouses, children are being employed. I don't know if it's intentionally or negligently, but it doesn't speak well for our country that would be happening. You mentioned one of the young people with you today who started picking fruit at age 14, did you say?
Correct.
Is that common?
That is common. Unfortunately, in agriculture, children can work in ag at a very young age. And so, you know, oftentimes you have parents, we're talking about poverty wages here, where farm workers are making between like median and mean somewhere between $17,500 a year to a little less than $20,000 a year. Those are poverty wages. And so, yes, sir.
Sorry to interrupt you, but I want to ask one other question. Mr. Litch, one of the proposals in the House of Representatives that passed on a partisan basis was to impose E-Verify on agriculture workers. That, of course, would check whether they're documented or undocumented. That legislation also included changes to the H-2A program, reversing a recent Department of Labor regulation setting wages. The bill did not include a path to legal status for undocumented workers, even though we know they make up at least 40% of the agriculture workforce. What would a mandatory E-Verify provision for agriculture workers do to the agriculture industry?
E-Verify alone, without some reforms to the H-2A program or a visa program, would certainly be devastating. I think both have to happen together. We live in and operate in states that currently do have E-Verify, and we comply with those laws. But I think for the ag sector overall, which is I think what you're asking, it would be pretty devastating to have that based on the percentage that you mentioned of workers that are undocumented. So both have to happen together. There has to be some type of H-2A reform, greater access to the program before mandatory E-Verify.
Mr. Carr, I'm going over a minute here, but I want to give you a chance to respond to Ms. Torres about practices at your farm. I want you to have a chance to say a word about it.
I'd be glad to. Well, first of all, Ms. Torres was referring to non-H-2A workers, and unfortunately, she was also referring to undocumented workers. This is one of the reasons why I joined the H-2A program 25 years ago. I have the oversight of the Department of Labor investigating or come and look at me every time. My payroll and my payroll records are published. They come in and look at those. Every employee on my farm gets a separate paycheck with their wage statement. So participating in the H-2A program is one way we can make sure that there isn't farm labor abuse.
Thank you. Senator Graham.
So let's see if I can do kind of a recap.
You and the nominee from California have been judge qualified by the American Bar Association, so there's no question about your experience in terms of your life and also your integrity. So I thank you for being here. Judge D'Alba, there was a point in your life when you were in private practice and established a workers' rights clinic. Why did you do that, and what was the result?
Senator, when I was a young child, I worked in the fields with my mother. And my parents were immigrants from Mexico. They had no education. We were field workers just to make ends meet. All of us had to work in the fields, my brothers included. One summer, my mother didn't get paid. She was promised to be paid next week. And it kept happening. We'll pay you next week. We'll pay you next week. At the end of the summer, the rancher filed for bankruptcy, and so there was no pay. That summer, we went without school clothes. So for that school year, we didn't have school clothes. And it stuck with me for various reasons. One, I vividly recall my mother crying in the bathroom. Like I heard her. She hid it from us, but I could hear her crying. And it just also so happened to coincide with, I have 3 older brothers, with the youngest of the 3 older ones having a growth spurt. So my poor brother had to go through the 8th grade with high waters because he outgrew his pants. And as much as my mom tried to undo the hem to get them to be long enough, it wasn't enough. He grew about 3 inches that summer. So it was that kind of experience that I had that led me to figure out a way, just if we could give people information. The clinic didn't take cases, the clinic didn't represent individuals, it just gave them information to know what their legal rights were. So it was a lived experience that I had that helped me put this together.
Thank you very much. I'm going to turn now to Senator Graham.
Thank you. Congratulations to both of you and your families. Judge,
Thanks, Judge Oliver. We'll have 5-minute rounds for each senator, and I'll start. It's interesting, I can't tell you how many times I've heard nominees come before us and tell their stories. And there are some recurring themes that always strike me, not the least of which is a salute to talent and hard work that each of these nominees and so many others bring to this room as they pursue their judicial careers. Also, salute to families. Over and over again, we hear from nominees how one family member especially, or perhaps 2, stood behind them at a critical moment in their lives and made the difference in their decisions on going forward. And I can't help but note, at least with 2 of our nominees today, also a salute to immigration. Immigration is what made America. My mother was an immigrant to this country, and I serve as chairman of the Senate Judiciary Committee. I hear on the stories of Judge Ali Khan what your parents and others in your family went through coming to the United States. I'm sure a treacherous journey in many ways, but the determination to come here and succeed and the pride that they take in seeing the next generation become leaders in our nation. Mr. Clerk, what an amazing story to be abandoned as a child and then to be part of a family of adoption that made the difference in your life and brought you to this moment in history. There's a lot of things said about immigration by politicians these days, but I hope that we'll have some honest reflection by all of us, the fact that immigration has made America what it is today as far as I'm concerned. Judge Munley, I listened to Bob Casey, who's a dear friend, and John Fetterman, who supports you as well, and I heard the story of your family. I was particularly struck by one incident in your life I'd like you to comment on. In private practice, you represented an emergency responder exposed to toxins and debris while working at Ground Zero in the disaster site at the World Trade Center after 9/11. You ultimately helped him recover an award from the 9/11 Victim Compensation Fund to compensate him for the health issues that he faced. Could you tell us a little bit about that experience and what it meant to you?
Thank you, Senator, for that question. It was an honor to represent that individual and to do that pro bono work. That gentleman left Luzerne County a day or 2 after 9/11 and threw caution to the wind without a care for his own well-being, got in a car and drove to New Jersey and made his way over to Ground Zero to help persons in any way he possibly could. And I had the honor of representing him right from the beginning through the process, gathering witness statements, interviewing individuals, getting all of his medical records to support the serious pulmonary injuries he sustained at Ground Zero. He gave everything during those days. It brought me back to the whole reason why I went to law school, to give back public service. If I have the honor of being confirmed, this would be a continuation of my life's commitment to public service and upholding the rule of law.
Thank you. Judge Ali Khan, as I look at your background as a Deputy Solicitor General and Solicitor General, you've had litigation experience which few nominees bring to this table. I notice that there's somewhat of a fraternity or sorority of Solicitors General across the country, and many of them have written in support of your nomination, even those of the opposite political party. What is it that you believe guided you in that pursuit?
Thank you, Senator. I was so fortunate to work with an incredible group of public servants across the country. And I think we all served different attorneys general. We knew that what united us was greater than what divided us, and that when we could come together and speak with one voice, it'd be a very powerful voice. Obviously, we oftentimes were on opposite sides of the litigation because we served different attorneys general with different priorities. But when we did that, we were on opposite sides of the V. We litigated with good faith and good humor. I think that public service is so important, and having the opportunity to work not just with dedicated public servants in the District of Columbia, but across the country has been just absolutely the opportunity of a lifetime.
And in all candor, you've been drawn into some political issues in your capacity, have you not?
Yes, Senator.
And it's interesting to note that the solicitors general who support you are both political parties.
Yes, Senator. We have a wonderful fraternity or sorority, as you said. I think one of the last briefs I filed before joining the bench had 39 state signatories, and I'm very grateful to have the bipartisan support that I do from that community.
Judge Oliver, many of my friends who are practicing attorneys long for the day and just have vague memories of an actual trial experience. It seems to be a hard thing to come by these days. I read here you've presided over approximately 320 cases that have gone to verdict or judgment. So you've seen your fair share of trials. Could you comment on that experience?
Thank you for the opportunity, Senator. I think the right to a jury trial, whether civil or criminal, is really at the foundation of our justice system. One of the things I would look forward to, or I'm so fortunate to be confirmed, is continuing to try jury cases, civil or criminal. In Connecticut, it's a bit of a lengthier process. In the federal district, it's a quicker process. Regardless, I think it's important that individuals, frankly, who have better things to do with their time nonetheless come in and dedicate themselves to the task of judging facts of complete strangers, taking the law from someone they haven't met before, judging credibility from individuals they haven't met before, deliberating to a common purpose in light of their experience, reason, and common sense, and attempting to reach a unanimous verdict on issues of guilt or not guilt or liability. I think it's so important, and I was fortunate to be able, in my time of public service, to take part as a prosecutor in about 24 criminal jury trials, and as a judge in about 300 bench trials, and then as a judge about 24 more criminal and civil jury trials. It's something I'm proud of. I think it's something that's important and necessary, and I look forward to the opportunity to continue to do so on the federal level.
Thanks, Judge. Senator Graham. Thank you, Senator Graham. Before I begin my questions, I want to remind my colleagues that following this open session, we'll have a closed session in SVC 217 at 12 p.m. today where you can pose questions that may not be able to be answered in open session. I'd like to start with questioning by just noting the following. I listened to how this program was described by our witnesses. Mr. Fanzone described it as an elegant program. Mr. Barnes described it as agile and specific. Mr. Cohen referred to precision. Mr. Olson that it was irreplaceable and invaluable, and so forth. But since the last reauthorization of Section 702 in 2017, many violations of the constitutional, statutory, and court-imposed restrictions on Section 702 have come to light. Last month, an unsealed Foreign Intelligence Surveillance Court, or FISC, opinion revealed that the FBI conducted improper searches of 702 databases for American communications 278,000 times. 278,000 times. These searches have affected all manner of Americans, such as individuals listed in police and homicide reports, including victims, next of kin, and witnesses to the crime. 133 people were arrested during the 2020 Black Lives Matter protest when, as Justice Department itself concluded, quote, there was no specific factual basis to think the searches would turn up foreign intelligence. And 19,000 donors to congressional campaigns when, quote, the only 8 identifiers used in the query had sufficient ties to foreign influence activities to allow such a search. 8 out of 19,000. Mr. Abate and Mr. Olson, you both testified regarding the remedial measures that have been implemented or are underway, but why should Congress or the American people trust the executive to comply with the law this time in light of this track record?
Thank you, Chair Durbin. I'll first take the question and then pass it off to the Deputy Director. As we both said, the problems that you've cited and that we've identified in our reviews of the FBI queries are not acceptable, and I don't defend them. I'm not here to do that. What I can tell you is that those problems predate the critical remedial measures that were put in place in 2021 and 2022. In particular, the FBI made a simple change to its system at the Attorney General's direction. Instead of, by default, when there was a query conducted by an FBI analyst or agent, searching all of its data, including FISA, raw FISA, and 702 data, it simply switched that to a default opt-in, so that from that point forward, starting in 2021, the FBI agent or analyst had to actually affirmatively take the step of saying, I'm going to conduct a search using a U.S. person identifier, and then say why that was reasonably likely to return foreign intelligence information. And it was that single change that has resulted primarily in the reduction of the number of U.S. person queries by 93% from 2021 to 2022. So it wasn't, again, these changes or these problems, these mistakes were not intentional. They were inadvertent. They're not defensible, but they were addressed largely by just simply requiring an affirmative step to search that data, because most of those searches were inadvertent. And if I may, one other point on the 278,000 number within the court opinion that you cited. Obviously, that's a huge number. The one thing to put that in some context, the one response to put that number in context, that doesn't represent each one of those a single wrongful query. Many of those queries were batch queries. In other words, multiple queries by one mistake, one agent making a mistake. In fact, one of those errors accounts for over 100,000 of the 278,000. So I think it's important to put that number, again, in context, again, not to defend or to excuse that mistake.
It's been a source of frustration since the creation of this program to get adequate accountability for the numbers, either on the positive side or the negative side. And you have to, I hope, understand why some of us are skeptical at this point that 278,000 doesn't mean 278,000. I'm not sure where you're going with that. Let me just ask the basic fundamental question in the few seconds I have left. Is the skill of our adversaries and the potential destruction that they could bring to us by their malicious acts really made the Fourth Amendment something that we have to question whether we can follow it in the 21st century?
So again, the FBI is committed, the Department of Justice is committed to ensuring the safeguards are followed with regard to 702. There is no diminution of the Fourth Amendment when we're talking about U.S. person queries. In other words, the answer to your question is we do not need to dispense with the Fourth Amendment. The Fourth Amendment applies fully to everything we do. In fact, it's the hallmark of the work that we do when we investigate and prosecute cases is to follow the Fourth Amendment along with the rest of the Constitution. The courts that have looked at this, had looked at FISA 702 and FBI queries, no judge has said that there is a Fourth Amendment requirement for the FBI to query the data that's already lawfully collected. In fact, the courts that have looked at it have said there is no Fourth Amendment violation or requirement. There certainly are privacy implications here, and that's why we've adopted the changes that we've talked about, and that's why the FBI has today announced additional compliance measures, which again are already proving to be effective.
I can't go any further because I've run out of time, but I will tell you that if the reforms that you've mentioned in 2021 and 2022 are the only reforms that you're bringing to this committee as we discuss the future of 702, I've got to see more. I hope there is more that you can present. Senator Graham.
Thank you, Mr. Chair.
Testimony. It's a cliche on this side of the table to say that our immigration system is broken. But when you hear the testimony of these 5 witnesses, you can't reach any other conclusion. From one end of the table to the other, you have given us a litany of failings of our current immigration laws. And sadly, most of those failings that you've talked about really relate to innocent and vulnerable young people who were caught up in a circumstance that was not their choice and whose lives are at stake in the process many times over. That is the reality. Ms. Bradley, thank you, you and your family for reaching out to help so many others. The two daughters that you've adopted, can both of them now legally work in the United States?
They can. Thanks to our Congresswoman, we were able to push through their employment authorization cards so that they didn't expire. So they are both eligible to work full. Yeah, one of them has a job. She's worked for 2 years. And the other one is able to work at a salon as soon as she signs a contract. So yes.
As you mentioned, they do not qualify for many government programs that other children may be eligible for. At this point, do you see them, let me ask you, what is their immigration status at this moment?
At this point, they have a special immigration juvenile status, which they got when they came into foster care. It was approved by a judge, and they applied for their green cards in December 2021, and we just have to wait 3 to 8 years for that to come.
I hope
So
it's
that's their
only
current
8
status.
years.
Yeah.
Ms. Davidson, you talked about attorneys representing these young people and said they don't all have legal counsel. Is that correct?
That is correct.
Okay. Do they have any representation at all?
So sadly, most children do not, and we want to make sure that kids have
You
access.
can get closer to the
Yeah,
microphone.
sorry.
That you appreciate.
Most children do not have legal counsel, and it's so important because it helps them comply with their immigration case, but it also gives them that trusted adult relationship to make sure that they have someone that they can talk to if they're concerned about their rights.
What about the phenomena that I've heard described where it's difficult to have a sponsor or even a member of the family to step forward because they're worried because of their own immigration status of identifying themselves to the government to unite with the children? Have you run into that situation?
Yeah, absolutely. I think, particularly under the last administration, when it was made clear that sponsor information would be used against them in immigration enforcement. So it is really difficult for sponsors to come forward. And we want these kids to comply with their immigration case because that's what they're guaranteed a right to have their case heard before a judge.
Ms. Basham, this sexual trafficking and sexual abuse that takes place, I mentioned earlier that I met with some of the migrants that were sent to Chicago from Texas when the governor decided to send them up, and sat down with them for several hours to talk about their experiences. There were no children involved in this interview process, at least of an age that they could tell me much. But I do recall a young woman who was about 30 years old who could have sat at this panel and looked like she was at home. She was a college graduate who made that trip to the U.S.-Mexican border, and she clearly was raped in the process. So the worst case, obviously, is child sexploitation, but it happens, obviously, at many different levels, and yet they still make the journey, knowing that danger lies ahead. I couldn't agree with you more that we have to find a way to educate, as President Obama tried with his statement, the families in these other countries about the dangers if they try to make this journey. What more do you think we could do at this point?
So that's a question that takes a lot more than 40 seconds to answer, but I'll tell you one of the things that's currently in Congress that will help right now is, I know TVPA is controversial, but there's a portion of the Frederick Douglass Trafficking Victims Protection Act that should be introduced shortly, and it deals with prevention education. And I will tell you that if when it comes to human trafficking, the biggest gap is in victim identification. Less than 1% of victims are ever identified, and if in general we had more prevention education and more children were able to come forward themselves and self-identify, if more teachers were able to identify, we would see a dramatic result throughout the country. So I think that's one legislative fix that's actually currently going to be in Congress shortly.
Thank you very much. Well, I'll start the 5-minute rounds and I'll begin. Lindsey Graham's my friend and my colleague. We see things differently and we still get along, which I think is the nature of good work in Congress, at least I hope it is. I would say to him, it is interesting to me that you cannot put a nominee for the Supreme Court of the United States at that table, and they all sit there, without that person expecting a question as to whether or not they're going to be influenced by foreign laws Will you look at laws in other countries, or are you going to stick with America? And the answer they're waiting for is, I stick with America. And now we have references to Europe as the standard bearer in terms of where America should go for its future. Secondly, if we're called an outlier in that headline, guilty as charged. America has always been an outlier. A written constitution for over 200 years, a Bill of Rights that people can depend on. We are outliers. No one in Europe can make the same claim. So I would just start with the premise, I love Europe, I love the Europeans, but we're Americans. And when it comes to the decisions as basic as the rights of our individual citizens and freedoms, I think we've got a pretty good starting point with the Constitution and Bill of Rights. I want to ask you, Dr. Lopez, there have been references made here to whether or not your profession and what you've done with your life for the last 10 years is an outlier itself, that in fact that you're not doing what is mainstream medicine in America. How do you respond to that?
That is not true. The type of care that I provide, gender-affirming care, is the mainstream standard of care, best practice, recommended by all the legitimate medical societies in the United States and across the world. And as I said in my opening statement, we have a clinical experience of more than 20 years and a robust body of evidence that supports this treatment as life-saving, decreasing depression and anxiety. There are no other studies that support any other treatment. So this is the mainstream treatment.
And accepted by the American Medical Association and the American Academy of Pediatrics as well?
Correct.
Is there any major professional medical organization in the United States of America that opposes this form of care?
No.
That speaks for itself. We're talking about science and medicine versus a political spin on the issue. I want to say I'm old enough to remember the debate on the Equal Rights Amendment 50 years ago. The fears, if we pass the Equal Rights Amendment, women will be serving in combat. You know what? Women are serving in combat because they want to serve in combat, and we need them. If we pass the Equal Rights Amendment, we're going to have men and women sharing the same bathrooms. Have you been to restaurants with all-gender bathrooms? I've seen them quite frequently in Chicago, and I'm sure you've seen them too. When I listen to Ms. Gaines, I think there's a fundamental call for justice in your statement. I understand it. We've got to be able to work that out as a nation, and not at the expense of Haley Walker and her future. There has to be a middle ground here that is fair to both. As far as I'm concerned, that's our job on this side of the table to deal with that moving forward. Dr. Lopez, you said, and I want to make sure it's on the record clearly, that accepted medical practice in this field does not provide for surgery for youth. Is that correct?
Their genital surgery is not recommended for minors. That is the standard of care.
And in terms of hormone therapy, it is not administered until after puberty?
That is recommended in adolescence.
And if you went forward with any surgery at any point, or even medications that we're talking, has it been your practice to involve the parents of the young person involved?
That is the standard of care. Parents, all legal guardians of parents have to consent to the treatment. That's part of the medical decision-making, is to involve the parents and discuss the risk and benefits like with any type of medical treatment. And at the end of the day, it is the parents that consent to the treatment.
Ms. Robinson, you've noted the resurgence, if you will, of anti-LGBTQ legislation across the country. A lot of it's focused on the transgender issue, but not exclusively when we look at the body of legislation. What else is coming up in the state legislature that concerns you?
I mean, we're concerned about bathroom bills reemerging, not moving forward, explicit non-discrimination for protections for the communities, and so much more. And for me, what's even more concerning is the violent rhetoric that surrounds every introduction of a bill. I mean, it's contributing to the fact that 1 in 5 of every hate crime is now motivated by anti-LGBTQ plus bias. This is an urgent problem facing our community and creating fear and isolation, even when the bills aren't passed into law.
Thank you. Senator Graham?
Thank you, Mr. Chairman. Ms. Robinson, the state laws that you referenced regarding transgender, do you think they're driven by hate, ignorance? What's causing this?
Thank you, Mr. Haji. I'm going to start the questioning, 5-minute rounds for each of the members of the committee present today. And let me say at the outset that the 3 judicial nominees have been judged well qualified, and that is a matter of record. And they certainly enjoy bipartisan support coming before us. And I wanted to just ask a question or two. Mr. Edwards, you've been a litigator since 2006, working in private practice and at the U.S. Attorney's Office in Shreveport. Before that, you clerked for 2 judges on the 1st Judicial District of Louisiana. So you've been acquainted with a number of federal judges. Tell me about the good ones and tell me about the bad ones.
Thank you, Chair.
You don't need to name names.
Thank you, Chair Durbin, for the question.
Be very careful here.
I've been very fortunate to work with many, many great judges. Judge Jeanette Garrett and Judge now Justice Scott Creighton were the judges who brought me to Shreveport in a way, because they offered me a clerkship while I was in law school from when I graduated. And they taught me the importance of being engaged in the profession. And I think that judges should be engaged in the profession to advance civility and professionalism and the rule of law in the community by making sure that people in the community understand how the system works. And so I learned that principally from them. And I can tell you that every judge in Shreveport is a great judge.
Pretty safe comment. Mr. Long, it's a lifetime appointment. Tell me your opinion of the qualities of a good judge.
Chairman Durbin, I think the qualities of a good judge are first and foremost faithfully following the law, being prepared, having command of the law every time you walk into court, being a good listener, being open-minded in hearing the testimony, seeing the evidence, and hearing the arguments from the parties, being respectful of the litigants themselves, and creating an atmosphere where decorum is paramount in the court, and being humble. Learned Hand said, "Know that ye may be mistaken." Realize when you need to give a matter an examination and a re-examination before rushing to a conclusion, because that's what the litigants expect and that's what the public expects from the judges.
Thank goodness on this side of the panel, humility is really the trademark of a senator. Right? Right. Judge Maddox, what's your experience and what would you say are the qualities that you look for in a judge that you practiced before or serve with?
Thank you, Chair. My very first lesson in judging was the importance of preparation. Preparation, and more preparation. And at the time of the hearing, keen listening. I agree with my colleague, Mr. Long, on that. Preparation is highly important because every hearing presents an opportunity for a judge to convince not just the litigants who appear before them, but also the general public that every litigant who does make an appearance will have their arguments and their positions considered very carefully by the judge. And it's only through preparation can a judge convey that through the questions that they ask at the hearing and through the comments that they make. And listening is equally important in that regard, and I've tried to convey and tried to emulate those qualities in my work in the past year and a half that I've served as a magistrate judge in the District of Maryland.
Let me ask Mr. Haji, since your selection is for a little different position of responsibility, you've had a lot of experience working on government contract matters, having served as a lawyer in the U.S. Navy for more than 10 years. You've worked on a range of issues, bid protest, contract claims, contract performance issues. How these experiences, do you believe, prepared you to serve on the Court of Claims?
Chairman Durbin, I think that the breadth of my experience, as you've described, is with the Navy doing government contract law matters. A big part of the docket of the Court of Federal Claims is government contract law matters. The court hears claims against the United States for monetary relief, and I've had a lot of experience working on claims against the United States for monetary relief in the course of doing government contract law work.
Thank you. Senator Graham?
Thank you, Mr. Chairman. I think this is a good example of how the committee can work. And
Senator Cruz, you're recognized.
Thank you, Mr. Chairman. I'd like to call up my amendment SIL 23800. This amendment is very simple. It consists of one sentence. The Supreme Court of the United States shall be composed of 9 justices. There has been considerable debate about the efforts of the radical left and the Democrat Party to pack the United States Supreme Court, to add 4 left-wing justices immediately to the court to grow the number from 9 to 13 because Democrats are unhappy with the decisions that are being issued by the Supreme Court. When FDR tried to pack the court, it was widely recognized to be a grotesque abuse of power, undermining the rule of law. That was true then. It's true now. Some Democrats in this body claim, at least when they return home and talk to their constituents, that they do not support packing the Supreme Court. This amendment is an opportunity to go on record and be clear whether or not you support packing the court. I would urge adoption of the amendment.
Thank you, Senator. The Constitution, of course, does not stipulate the number of Supreme Court justices. That is a decision of Congress. We have a long history of altering the makeup of the court. The number of justices has changed 6 times before we landed on the number 9 in 1869. There's only one living senator who has changed the size of the Supreme Court. That is Senator Mitch McConnell of Kentucky, who shrank the court to 8 seats for nearly a year and for purely political reasons, so he could refuse Merrick Garland's nomination by President Obama. Republicans engaged in court packing plain and simple when they refused to consider then-Judge Garland's nomination in 2016 and then hurried through Justice Barrett's nomination in 2020. My Republican colleagues routinely try to forget and ignore this history. Republicans' insistence now that the Supreme Court must remain at 9 seats and their hysteria over Democrats even discussing a change does not square with that count that I just gave you. Ultimately, however, this amendment is unrelated to the bill before us and the very real need to ensure the courts put in place an enforceable code of conduct. I will therefore oppose the amendment. Anyone else seek recognition?
Mr. Chairman,
Senator Cruz.
if I could respond briefly, it is true that Congress has the authority to change the number of justices on the court. The last time Congress exercised that authority was in 1869, just after the Civil War. So it has been a long time that we have had 9 justices. That is why when FDR tried to pack the court, even Democrats said this was an abuse of power. It's an interesting commentary that in the 1930s, Democrats in Congress recognized that packing the court would do real damage to the rule of law, to the Constitution. Today, Democrats no longer believe that. The chairman tries to engage in wordplay by saying the Senate exercising advice and consent is somehow packing the court. It is true that when President Obama nominated Merrick Garland, the majority of the Supreme Court made the decision not to confirm him. That is not packing this court. That is exercising the constitutional authority of the Senate to advise and consent, and in that case, to allow the voters to make a decision. Justice Scalia passed away in February of a presidential election year, and the history had been true for 8 decades that when a vacancy occurred in a presidential election year and the Senate was in the opposing party's hands, the Senate did not fill that vacancy, but rather allowed the voters to decide. That's what the Senate did. I understand Senate Democrats are unhappy about that. I also understand Senate Democrats wish Hillary Clinton had won instead of Donald Trump. That's not, in fact, what happened. Packing the Supreme Court means one very specific thing: adding additional seats to change the balance of power because you are unhappy about how the Supreme Court is ruling. It is directly interfering in the administration of justice, and it is profoundly dangerous. And I got to say, it's going to be sad, but it's going to be revealing. The next time some Democrat goes on the trail and says, no, 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 we're not going to pack the court, just remember what you're about to see, which is going to be every Democrat voting against the Supreme Court consisting of 9 justices, because today's Democrats, it is partisanship above all else, including the rule of law. This bill reflects that, and a willingness of Democrats to try to undermine the legitimacy of the Supreme Court. But the willingness to pack the court shows just how radicalized today's Democrats have become.
Chairman.
I'll recognize you in just 1 second, Senator Whitehouse. Perhaps the senator from Texas recalls a meeting of the Senate Judiciary Subcommittee on Oversight, which you chaired, and in which you accused the Supreme Court of activism and called for the need to, quote, rein in judicial tyranny over the Obergefell decision. Last month, shortly after the High Court handed down a 5-4 decision that made marriage equality the law of the land, you vowed to propose a constitutional amendment that would effectively upend Article 3 of the U.S. Constitution and subject justices to periodic retention elections. The sacred number 9 was not honored during the month of 2016 because it was last year of Obama's presidency, unpacking a court by Senator McConnell with the express purpose of a political result. So I still oppose this amendment. Senator Whitehouse.
Thank you very much, Mr. Chairman. Like so many of our Republican friends' amendments today, this is not related to the bill at hand. And I would note that we are here discussing this because of the ethics mess that has taken place at the Supreme Court. We certainly know that a lot of improper things have happened and have not been disclosed. I think the multiple billionaire-funded private jet flights to various places are pretty self-explanatory as inappropriate. The excuses that have been made to try to justify them don't pass the test of, frankly, what other federal judges would tolerate in a courtroom. And until we know what the true depth is of the problem at the court, it's impossible to know what the appropriate response is. So I have not spoken out in favor of adding a number to the court, but I don't think we should foreclose that in an amendment here because we don't know yet what the whole story here is. We have a lot of investigative work to do to get to the bottom of it. We saw another important article come out just this morning about the nexus between Leonard Leo and his front groups and his billionaires who fund him and one of the justices on the Supreme Court. It just keeps getting worse. So I would urge a no vote on this amendment, and I believe we have a quorum to vote.
On the Cruz Amendment 23800, the clerk will call the roll. Consideration is S 359, the Supreme Court Ethics, Recusal, and Transparency Act, CERT. The past several months have seen a steady stream of news reports highlighting ethical failures by the highest court in the land, the Supreme Court justices appointed by both Republican and Democratic presidents. Justice Clarence Thomas traveled the world on billionaire Harlan Crow's yacht and private jet. Crow bought the home of Justice Thomas's mother and allowed her to continue living there rent-free. He even paid for the education of a relative of Justice Thomas. None of this was included in Justice Thomas's financial disclosures. Justice Samuel Alito took an all-expense-paid luxury fishing trip to Alaska. He traveled there on the private jet of billionaire hedge fund manager Paul Singer. He stayed at a fishing lodge of conservative donor Robin Arkley. Like Justice Thomas, Justice Alito did not disclose any of these receipts. In explaining this, Justice Alito said he did not believe he was required to disclose the private jet travel because he was sitting in a seat that would otherwise have been empty. Justice Sonia Sotomayor used her tax-funded court staff to promote additional sales of her books in conjunction with speaking engagements. She failed to recuse herself from cases involving her book publisher. If any of the senators or even the staff members sitting in this room today were involved in similar activities, they would be in violation of the ethical rules that govern Congress. That's because all of us are subject to enforceable codes of conduct that prohibit us from accepting gifts and using taxpayers' funds for personal gain. We are required to make public disclosures about our finances, and there are consequences if we fail to meet these standards. But the same is not true for the 9 justices across the street. Unlike every other federal official, Supreme Court justices are not bound by a code of ethical conduct. They are the most powerful judges in America, and yet they are not required to follow even the most basic ethical standards. The CERT Act we are considering would change that. It would finally require the Supreme Court to adopt an enforceable code of conduct. It would also add new recusal and transparency requirements to federal law. In this way, it would bring all 9 justices of the Supreme Court in line with every other federal judge in America. Requiring a code of conduct for Supreme Court justices should not be controversial. Historians and legal scholars from across the political spectrum agree that legislation imposing a code of conduct on the Supreme Court is both necessary and well within Congress's congressional authority. Members of this committee on both sides of the aisle have long led efforts to make the Supreme Court more accountable and transparent. In 2021, our colleague Senator Cornyn, along with our colleague Senator Coons, introduced the Courthouse Ethics and Transparency Act, which required all federal judicial officers, including Supreme Court justices, to file disclosures of certain securities transactions, just like members of Congress. That bill passed the Senate unanimously, both parties, and was signed into law by President Biden, and the Supreme Court is abiding by this congressional action. 2 years ago, this committee, with the support of 5 Republican senators, favorably reported Cameras in the Courtroom Act, a bipartisan bill that I've long introduced with Senator Grassley, and which would require the Supreme Court to permit television coverage of all sessions of the court with only limited exceptions. Some have suggested that Democrats are pursuing Supreme Court ethics reform to target the court's current right-wing majority. Far from it. The reforms we are proposing would apply in equal force to all justices. And, as I mentioned, it was more than 11 years ago, and a very different Supreme Court, when I first urged the Chief Justice to adopt a binding code of conduct. Unfortunately, he did not accept my suggestion. Since then, as more and more stories have emerged of justices' ethical lapses, the American people's confidence in the Supreme Court has dropped to an all-time low. My colleagues, the Supreme Court term begins with the announcement by the Marshal of the United States Supreme Court. He strikes a gavel and he says, "The Honorable, the Chief Justice and Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having businesses before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court." 3 times the Marshal declares that the Supreme Court is honorable. With the enactment of this legislation, our highest court in the land can more rightly make that claim. I now yield to Senator Graham.
Thank you, Mr. Chairman.
The senators of this committee for this incredible opportunity. I look forward to answering your questions today.
Thanks, Ms. Robinson. So I read here, the job you are seeking advises the president and coordinates with departments and agencies on matters of intellectual property policy and strategy. Seems like a pretty big job.
Yes.
Pretty important job.
Yes.
So let me confess, I'm going to ask you a question and I don't expect you to answer it, but you may try and maybe do much better than I expect. And it's on something called artificial intelligence, AI. The presiding Democrat in the Senate is Senator Schumer. And Senator Schumer has taken an intense personal interest in artificial intelligence, to the point where he's had several high-level briefings that he's invited his colleagues in the Senate on a bipartisan basis to attend. I have done my best to try to understand this issue through the eyes of a liberal arts lawyer, which doesn't take me very far. But it seems that AI, artificial intelligence, would have some real relevance to the future of the area of interest that you're seeking. Would you like to make a comment on that?
Sure, Senator. First, I think that AI is both a promise and a concern. And a concern in that AI could lead people to more infringements and to more counterfeit goods. But I think that I need to get more information before making sort of like a broad comment on AI, because intellectual property is decided on a case-by-case basis. And I wouldn't want to use a broad brush to talk about an emerging technology that is developing still. But what I will say is that I know that there's a lot of research being done right now, and if I'm confirmed, I will make sure that I learn about all the research being done on AI, that I stay abreast of conversations, and I actually applaud this committee for starting that conversation about AI. And I would absolutely stay abreast of conversations, and in that context, the question that I would have when looking at the research and at those conversations is, how will AI affect American jobs? How will it protect the health and safety of the American people? And how will we use AI or combat things that result from AI to protect innovation, to protect creativity, and to make sure that all Americans are safe?
That's all I could ask, and as I said, I didn't expect the answer to completely exhaust the subject, because it is almost unlimited in the applications. I was just paging through here as well, Judge Bryan, because it said at one point that you have handled 8,000 cases. Is that true?
As a district court judge in St. Paul, I was assigned to various types of cases, and adding them all up is more than 8,000 that I was assigned case numbers.
Some experience. And what about trials?
Well, as a practitioner working for the United States Department of Justice, I had trials in federal court as a federal prosecutor. As a judge, I estimate between 100 and 120 trials that I presided over. That doesn't include some of the petty misdemeanor trials that are trials that would number in the hundreds.
Quite a lot of experience. Judge Lee, I can recall appearing as a small-town attorney before a federal judge, and knowledge of the law was important, knowledge of the facts was critical, but the temperament of the judge had more to do with the outcome than almost all the work we did in preparation. Can you speak about the temperament of a federal judge who, if they're successful, ends up with a lifetime appointment?
Thank you for that question, Senator Durbin. I would have to go back to the judge who I clerked for on the district court, Jerome Turner. He was somebody who, no matter what his views were, no matter what he had for coffee what he had for breakfast that morning, his temperament on the bench was even-handed, fair. He always treated every litigant as they were the most important ones in the room. He always made sure that he was well prepared, and he treated each case as though it was the most important. And I think bringing all those qualities, that is what our litigants deserve in our courtrooms every day. That is what I try to do. And he did it all with this incredible depth and humility.
Thank you. Senator Lee. Thank you very much, Judge Kohler. We each have 5-minute rounds to ask the nominees questions, and I'll start with Mr. Federico. I think we have considered approximately 157 nominees for Article III judgeships before this committee in the time that I've been the chairman. And I would say that it's pretty predictable how each of us react after all those experiences and all the different nominees. There's a feeling among some that anyone who is a public defender is soft on crime and won't take it seriously. And they'll go back in cases that they defended and say, that criminal defendant was a bad guy, and you stood up for him and fought for his rights in court and did your duty as a defense counsel. And they'll think that that really tells the story of what kind of judge you may be. Now, you have a confounding background when it comes to that, because you've served as both a prosecutor and as a defense counsel in your career, and certainly during the time you were serving in the Navy and Navy Reserve, I'm sure you had opportunities to deal with both sides and both tables in the room. What can you tell us about your background that would assure people that you will be fair-minded and not lean one way or the other when it comes to criminal cases?
Mr. Chairman, as you noted, I have served as a Navy prosecutor. My first full active duty tours were as a Navy prosecutor, first here in Norfolk, Virginia, and then overseas in Europe and Southwest Asia. So I had the experience as a prosecutor before I received orders to then go on the defense side at the military commissions, and then I later was an officer in charge of defense offices. So as an active duty judge advocate, I certainly experienced both sides of the aisle. I think that makes me potentially understand the equities that the parties bring within the courtroom. Of course, later in my career, I've become a military judge, and so transferring from an advocate onto the bench to neutrally decide the issues that are before me in cases, I know that I was able to lean on my experience as a prosecutor and as a defense counsel and as an appellate defense counsel in my reserve capacity. So certainly in my military career, I have done both sides of the aisle, and I know that can only make me a better circuit judge. As a federal public defender, of course, I get court appointed to represent persons charged in federal court with crimes. But again, my job, and I believe very strongly in the Sixth Amendment and the right to counsel, and what a great country and system we have, that not only do we afford counsel to persons that are charged, but we demand that that counsel represent them zealously within the bounds of the law. So I take that oath I took as a lawyer, similar to the oath I took as a naval officer, very seriously. And I understand that crime impacts all of our communities. I've worked with victims directly, with victim outreach, and so I understand that side of it as well. It is my hope and belief that all of those experiences will make me a better circuit judge should I be confirmed.
Thank you. Judge Kohler, I have to confess a conflict of interest. Wayne Anderson has been my personal friend for decades, and we went out to dinner together just a few months ago. I know you clerk for him, and he's now in private life, but he's a member of the other party in my state that I've respected and counted as a friend for a long period of time, and I'm sure you feel the same about him. Yes. How about this world of appellate practice? Tell me about your preparation for that.
Thank you, Senator. I started at the U.S. Attorney's Office in the Northern District of Indiana as the appellate point of contact, and I was fortunate enough early in my career as a federal prosecutor to focus on appellate work, and I drafted or argued over 20 cases in the Seventh Circuit Court of Appeals, and that was an experience that laid the groundwork in a very real way for my career on the bench now and my time as a federal prosecutor. It allowed me to see how a record develops and how that translates into appellate practice, and gave me deep familiarity with the entire spectrum of a case from the beginning to end. It helped me in avoiding issues as a prosecutor when I later went on to prosecute complex cases, and I think it's prepared me well for the position of circuit judge.
Thanks, Judge Kohler. Senator Graham.
Thank you, Mr. Chairman. Yeah, I try to be open-minded and broad.
We have a round of questions from the senators. Each have 5 minutes. I'd like to direct my question to Secretary Janulius. The American Library Association has written the following: 1,269 demands to censor library books and resources in 2022. The highest number of attempted book bans since ALA began compiling data about censorship in libraries more than 20 years ago. The unparalleled number of reported book challenges in 2022 nearly doubles the 729 challenges reported in 2021. My first part of my question is going to ask you to address that statement by the American Library Association in light of testimony before us that this is much ado about nothing. And the second one is the notion that extremist attacks on student and book bans are not that prevalent. Book banning has reached new heights over the past 2 years. Local leaders in states such as Texas, Florida, Utah, Missouri, Iowa, Indiana, and others have all recently enacted legislation facilitating banning books in local school districts and libraries. These new laws provide for civil penalties and/or jail time for violations and pose great risk to teachers and librarians. And that's why groups like the American Library Association have spoken out. Can you reflect on those two statements?
Thank you, Mr. Chairman. The two are related. As state librarian, I travel the state of Illinois, and we talk to librarians, we talk to libraries, school libraries, public libraries. The level of threats, intimidation, physical threats, in talking to librarians, these are not my viewpoints, they have never seen it in their entire careers. Because of these political attempts to ban books, we're seeing libraries close down at record numbers. It's difficult to find new librarians who want to serve in roles that used to be their dream jobs. And just a few weeks ago, in the suburbs of Chicago, numerous libraries received bomb threats and were forced to close their doors. So I can tell you, in Illinois, it's very real, and across the country, the problem is worse. And again, what our bill aims to do and will do is to fight for and protect these librarians. We have to fight for our librarians. We also have to trust that they have the professional judgment, experience to make decisions on what books belong in circulation. It should not be up to fringe elements screaming from the rooftops about books that they've never read. These are librarians and individuals that have advanced degrees in library science, masters of library science, masters of information and library science, and it's important to make sure that we allow them to determine what's in circulation, and it's important for us to trust parents to determine what books their kids should read. And again, it is not up to parents to tell other parents what books kids should read. Another point I'd like to make when it comes to our legislation. We are not advocating for any single book to be at a library or not be at a library. What we're saying is let's trust our librarians to make these decisions, not an individual parent that's angry or disagrees with a certain viewpoint. Judy Bloom said recently, "I believe that censorship grows out of fear. And because fear is contagious, some parents are easily swayed. Book banning satisfies their need to feel in control of their children's lives. This fear is often disguised as, quote, moral outrage. They want to believe that if their children don't read about it, and then their children won't know about it. And if they don't know about it, it won't happen. As I mentioned in my opening remarks, I have 3 young daughters. Of course there are books that are not age appropriate, but that's what being a parent is all about. Doing your best to keep an eye on what your children read and what they consume." Thank you, Mr. Chairman.
I would just add as well that putting this in the context of the world we live in, where so much information is so available to people carrying simply iPhones or any laptop computer that they have access to, that we ought to be honest and realistic about that. I agree with you. The first responsibility is the parent's responsibility. And we believe there are age-appropriate restrictions that can be introduced in libraries and other places, which generally are consistent with freedom of expression. I thank you. Senator Graham.
Thank you. Let's just build on what has been said. How do you say your name, sir? Alex?
Alexi Janula.
Turn to at this time. I'm ready to do that at any point. I think we need to do so.
Mr. Chairman, I take you up on that. Bring the bill forward. Let John tell us what he doesn't like about it, how he can make it better, and let's vote. America is really in a national crisis, according to the mayor of New York City, not Lindsey Graham. This is incredibly dangerous, incredibly irresponsible. Afghanistan is now in the hands of the Taliban. The threat of terrorism against the United States is getting worse, not better. ISIS smugglers are involved in getting people into the United States. I think if you brought the Gang of 8 bill or any other bill as the base bill and have a debate on it, this committee would be well served. We could all vote, we could all amend it, and I look forward to doing that.
So let's start by having our staff take a look at the bill. What is it, 7 or 8 years now?
Count me in.
And let's update it, which I'm sure we'll have to do in some respects, and see if we can move it forward. As long as it's bipartisan and has a chance of passing in the Senate as well as the House, I think it's a good effort.
Mr. Chairman, if I could just respond briefly. I can't even remember when the Gang of 8 bill was on the floor. Was that 2016? 13. Oh, 10 years ago. And it didn't pass the House. I mean, I know you are proud of that product, but unfortunately, it didn't pass the House. And of course, as we all know from Schoolhouse Rock, a bill becomes a law when it passes both chambers of Congress and gets a presidential signature. So forgive me for saying this, but that bill failed to succeed. I know you're proud of it, but that was also at a different time than we're in now. And before the Biden border crisis became so dire. And I think there's a different dynamic. Certainly there's a Republican House. They're not going to take up and pass the Gang of Eight bill. You know that. I know that. Everybody knows that. So forgive me, but when you keep talking about the Gang of Eight bill as somehow being the gold standard, I have to disagree.
Mr. Chairman, may I ask you a question?
You may.
Mr. Chairman, I wasn't here when the bill that you obviously favor was considered by the Senate. My question's simple. Did it grant amnesty to folks who are in our country illegally?
No, Senator, I don't believe it did. I think the decision in the bill was that those who are undocumented, currently living in the United States, would report themselves to the government and pay their taxes and their Social Security. They would not qualify for citizenship, at least in the outset. And the idea was to get everybody on the books once and for all. I think that is a positive step forward. It did have favorable sections for dreamers, which you can imagine I had some interest in. But there were several things.
How is that not amnesty?
DREAM Act?
How is that not amnesty?
Well, it isn't as if they're being forgiven for wrongdoing. They were brought to this country as children and infants. I don't think that there was any culpable conduct on the part of these dreamers, if you wish.
So you were allowed to register, and if you registered, you could stay indefinitely?
No, there's a path to citizenship for dreamers. But there was no culpable conduct on the part of infants brought here to this country.
I'm just trying to understand. It just sounds to me like that's amnesty.
In your eyes, it may be, but if a child is brought here at the age of 2 to say that they are guilty of some criminal act or should have criminal culpability, I think is an extreme position.
Well, I'm not trying to say 2-year-olds are bad people. I'm just trying to understand what your bill does, and it sounds like it's amnesty.
It's lengthy.
If I may, Mr. Chairman?
Sure.
I was part of that, and sort of here's what I'll tell my good friend from Louisiana. You got to get bipartisan buy-in, right? You got to secure your border. If you don't, it's a fruitless exercise. You need to increase legal immigration because we don't have enough people to work in our economy, and you need to deal with people here legally, and I've been very open to doing all those things. But it is 2023, and Senator Cornyn mentioned our effort didn't make it. If you want to use it as a base product, fine. But even I would say in 2023, the problem is so much bigger than it was before. It would take more effort on the border. It would take a real lift to stop the flow, and I'm willing to work with you. I'm willing to compromise, but the administration has done nothing. Senator Kennedy, they sent a bill that nobody on our side would support, and it was a dream of the left. I mean, again, at the end of the day, I don't mind disagreeing with Republicans about how to fix an immigration system. I do mind doing nothing about it. And the sooner we can have this debate in this committee, and you may be surprised, there might be consensus, big bill, small bill, middle bill, something's better than nothing. America is under siege, and we need to fix this problem.
Mr. Chairman.
Just a second. We're going to return to the subject of this hearing shortly. What Senator Klobuchar.
I'm looking forward to hearing the witnesses, but Mr. Chairman, I did want to point out the argument that nothing has been considered for 8 years or something like that. I actually view, when you look at the arc of time on this, when President Bush was in, he wanted desperately, Republican president, to get this done. I remember Senator Graham was in the group that worked on this. Then you fast forward, right, to Obama, and this is the effort you're talking about during that time. But even during President Trump, there was a major effort made, led by Senator Rounds, if you remember, an introduced bill that was maybe what Senator Graham was getting at when he talked about a more limited bill. It had funding for the border, significant funding for the border, but it also included more work on work permits and
on visa, something people on this committee and a number of people on both sides of the aisle care about very much. Dreamers were covered under that bill. Temporary status people who are already here were covered under that bill. I don't remember every single detail, but I do remember is that we had enough Republican senators to get it over the line. The House was going to pass it, and then unfortunately, President Trump rejected the proposal, and so then it died. That is what happened. I only point that out because that was a very recent bipartisan effort compared to the one that was 8 years ago. So this has continued, and there has been to say that this was about amnesty or any of that, this was actually about moving our country forward because, yes, border, do more, but no great country has expanded with a shrinking workforce, and we have made it so difficult for doctors and nurses and for people that want to be here. It has made it really hard in many of our states, in the ag sector, in the hospitality sector, and others. And I just believe immigrants don't diminish America, they are America, and we have to find a way to do this. And one of the arguments that always seems to get lost is the economic argument for how important this is right now for our country's future.
Thank you, Senator. Senator Whitehouse.
I just wanted to observe, Mr. Chairman, your long and passionate advocacy for immigration reform, particularly around Dreamers, and recognize the ranking member for his helpful participation in multiple efforts at reforming the immigration system. I think with you both as chair and ranking member, there really is a prospect for doing something bipartisan and useful in this committee, and count me in. I would also flag that the next budget committee hearing coming up is on the economic value of more robust immigration, which has very powerful economic value for Americans. Thank you.
Mr. Chairman, if I may, and I'll
Senator
get you,
Graham.
I know you want to conduct the hearing, but I'm glad I brought this up. Seems to be there a lot of interest about what to do. And the bill that Senator Klobuchar mentioned got 54 votes. I remember it well. There are many combinations, small, medium, and large. The problem is not just small, medium, and large, it's unbelievably out of control. I've been doing this since 2006. I never dreamed that we would be where we are here today with policies that basically are in shambles. Whether you like President Trump or not, we had the lowest illegal crossings in the last 40 years on his watch. Now, what happened? Democratic president changed all those policies, and we have a tsunami of illegal immigrants that are destroying New York City and other cities. Rather than talking today about what we should do, I don't care what the base bill is. It could be what Senator Klobuchar said. It could be any bill you want as the base bill. I'd like to get this committee involved in trying to fix this problem.
I accept your invitation to be part of that, and let's do it starting with that bill, perhaps others. Today, we of this committee, we came together and put together a bipartisan effort. Among the sponsors over time were myself, Senator Whitehouse, Senator Grassley, and others. The notion was that the prison experience should be more than punishment and separation. It should be perhaps a new look at life, a life-changing experience in a positive way. And our measurement for that is quite simple: recidivism. How many people leave our prison system and commit another crime, another victim along the way? And that's very basic. And I think the record, as I've read, and I hope it's the same that you said, is pretty interesting. We know that generally recidivism rate of the Bureau of Prisons population stands at 43%. 43% commit another crime after release from prison in the Bureau of Prison system. However, if they've been through this program in the First Step Act, only 12.4% recidivate, and 87.6% don't. That's dramatic. It means time well spent, resources well invested, not to have a recidivism situation like this. So tell me where we are in terms of providing the resources for more participation and whether or not we need to do more.
Thank you, Mr. Chair. I think we always need to do more. As of the beginning of this month, we were offering over 110 structured activities. About half of those were evidence-based recidivism reduction programs, and the other half were those productive activities. And you're right, the data is very clear. I think that we are at a great moment in time as we pivot out of the pandemic, and we have institutions that are now thinking very creatively about the programs that they can expand now that we don't have institutions under lockdown. Furthermore, as we continue to tackle this recruitment and retention issue, you're going to see even more progress because we'll have fewer people engaged in overtime and augmentation, freeing up individuals to engage in those programs and those activities.
So let me talk about Thompson for a minute, and I mentioned it in the opening statement. How did Thompson reach that point? Such a low point that you had to virtually close the mission of that institution. And what happened to the people who were in that institution? Are they gathering in another place? Were they sent to another place? How do you know we're not going to have the same problem wherever they're sent?
Thank you, Senator. I don't know how an institution gets to that low point. As you said, the warden reported he hadn't seen anything like that in his career. I, too, hadn't seen anything like that in my 30-plus year career in corrections and law enforcement. And so those individuals who have engaged in that behavior have been referred for an investigation. Some have left the organization. Some are pending criminal investigation. Others pending administrative investigation. For those that were moved out of the institution, we are paying attention to them and their behavior. We also have really increased training at that institution. When we were able to shut that institution down, we really went back to basics, went back to corrections basics, and rebooted our training program there so that we could change that culture. Culture change takes time. I think changing that institution's mission to a low security mission will help in rebuilding that culture and making that change. And we will be keeping a very close eye on that facility.
How much do you attribute this to understaffing and augmentation?
Senator, I think that accountability is the most important thing. I don't believe that a lack of staffing and augmentation leads people to treat other human beings that poorly. And so for me, it was violations of policies, practices, violations of best correctional practices. And so I wouldn't want overtime or augmentation to minimize the egregious choices that these employees made in taking care, or rather not taking care, of those in our care and custody.
I'm glad you took this job. It is historic that you're in this capacity. Certainly the first year I felt, I don't know if others shared it, I think they might have, that you were entitled to the preliminary opportunity to assess the Bureau of Prisons and to talk about change and maybe even initiate some change in that first year. We expect much more in the second year. What can you tell us?
So I think we have great plans for the second year. So the first year we really did an assessment, developed our executive team, engaged in the strategic planning, as I talked about in my opening comments, which I think is really going to set us on course for some initiatives that are going to improve employee wellness, really focus on restrictive housing, and implementing these principles of normalcy and humanity throughout the institutions. We've opened our doors to members of Congress and others to come in and see what we are doing. We're collaborating very closely with the Office of the Inspector General and the GAO so that our doors are wide open to them in terms of oversight and accountability. So I think in this next year, you will see the advancements of our strategic planning, the change in our mission, and a true focus on our new core values.
Thank you. Senator Graham.
Thank you very much, Ms. Peters. I appreciate your efforts on behalf of
full employer hiring practices. Thank you, and I'm happy to answer any of your questions.
Thank you, Mr. Morant. Now we'll have a round of 5 minutes questions from the senators, and I'll start. The first person who introduced me to the world of politics taught me something. He said, humility is the first casualty in politics. So I have followed that standard when it comes to bragging as often as possible about the fact that my mother was an immigrant to this country, and I'm damn proud of it. Her naturalization certificate sits behind my desk in the Capitol building as a reminder of who I am and where I come from, and my attitude about immigration. I cannot understand anyone, regardless of political affiliation, who takes the position, not one more immigrant. For God's sake, We are a nation of immigrants, and our strength is in immigration and diversity. The question is, should we have an orderly process or not? I think that's a legitimate question. The reason, of course, is to make sure that we have a process which people can respect, that cannot be overwhelmed, and at the same time understand that there are rules that have to be followed. When you take a look at the numbers of people who are showing up at our borders now, I have to go back to what Senator Graham said. They're mind-boggling. It is impossible to explain. I asked my staff to put together a list of the number of encounters of unaccompanied children by the Border Patrol since 2008. It's an incredible list. But the last 3 years are the most amazing revelations. In the year 2020, there were 19,657 unaccompanied children who were encountered at the border. 19,000. 2021, 140,000. 2022, 149,000. 2023, 131,000. The obvious question is, what changed and changed so dramatically during that period of time? It certainly wasn't the enactment of legislation by Congress. We've done nothing, virtually nothing, when it comes to policy changes in this country. But there is something going on, a force, an economic force, a demographic force, whatever it may be, that is pushing or pulling more and more people to our borders in numbers unprecedented. The obvious question is, should we do something about it? And can we do something that is balanced, not the not one immigrant theory and not the people who feel that the status quo is acceptable as it exists, but something in between that reflects our values and brings order to the border. Now, I think about these numbers in practical terms. I hope we all accept the premise of this hearing. Any child who shows up at our border deserves to be treated like a real human being and treated like a visitor to America and given protection and help in the areas when they're most vulnerable in their lives. I hope we all accept that premise. If you don't, I'm sorry. But I will tell you this, having accepted that premise, you have to ask whether the current system, designed long before we ran into these numbers, is adequate to the task. Where are these kids going? Where do these unaccompanied children go? What kind of families are they being sent to? How do they refer them? How do we follow up? How do we make sure that they're safe once they're there? The sheer numbers that I've given you here make it very difficult for me to understand how we can say we're going to keep up with this flow of people and maintain quality care for these kids. So I've given a long opening statement, which I hoped I would be able to avoid, but couldn't. But I'd like to start, if I could, with Mr. Salazar. You talked about the economic circumstances that create this. But those economic circumstances have been in the world for a long time. What has changed in the last 3 or 4 years?
Thank you, Chairman Durbin. These push factors, as you mentioned, the political stability, the poverty, the crime, violence, food scarcity, lack of medical care, climate change, all of these are against the backdrop of some even bigger numbers in the world. There are approximately 108 million people that are being forcibly displaced globally. And of that number of 108 million, roughly 20 million are in the Western Hemisphere. I mean, this is the definition of a challenge that no one country can face alone by itself. We have issues stemming from a long regime in Venezuela. We have issues stemming from the beginning of a regime in Nicaragua. We have issues in northern Central America also that are driving the families, the members of society there to make difficult choices for themselves and for their families and for their children to head north. We are attempting to tackle this diplomatically through regular engagement with these countries to try and address the issues at home. That is why Assistant Secretary Brian Nichols is actually in the region now. Yesterday he was in Guatemala, today he is in El Salvador.
I'm going to have to cut you off because I've run out of time.
I'm sorry, sir.
But I certainly give you time to respond on the record. But can someone address on the panel the fact that we offer services which we offered for many years, and now we have volumes and numbers of unaccompanied children which are breaking the system that make it very difficult for us to keep our promise? Would someone like to talk about the resources that are being dedicated to this, new resources to meet the challenge?
Thank you, Senator. As you mentioned in your opening, the importance of a trusted adult in these children's lives cannot be overstated. Children, we do our best. We have a thorough vetting process to release children to vetted sponsors, primarily close family members. But when and if those placements break down, having that trusted adult through post-release services or legal services. We have more children receiving those services than we've ever had, but we need to continue, and we need the support of Congress to do that. Because of unprecedented numbers in the refugee program, which both the refugee program and the unaccompanied children is one budget, we do have a request for $1.9 billion to be able to properly continue to expand and make sure that all children have these services.
Thanks, Ms. Marcos. Senator Graham.
Thank you, Mr. Chairman. Count me in the camp that we.
There's so many aspects of your career that I could speak to, but I want to raise a question about something that you've identified as an important part of that career. We ask you to identify the cases you've been involved in that you wanted us to take note of. And the fifth case is one entitled the United States versus Smith. In that case, you represented the United States prosecuting at trial, on appeal, and in post-appeal litigation. It involved a defendant who had produced child pornography images by raping a 3-year-old girl and capturing the encounter on video. The defendant was ultimately convicted and sentenced to 600 months of imprisonment. The conviction and sentence were affirmed on appeal. The reason I raise this case is because of the note that you've included in describing the case. And you said, an important part of the trial preparation was helping the victim's parents deal with feelings of guilt and allowing the defendant access to their daughter. The reason I raise that is this has been an issue which we've considered in this committee, something known as CSAM, child sexual abuse. It is an outrageous situation, horrible, and has impacts on children which go far beyond the obvious. And it appears that this case that you represented the government in at least touched on that same concern that we all share. We passed a bill out of this committee unanimously to deal with the people in big tech and their response to try to protect our children. As a parent and grandparent, I live in fear of this little piece of technology. And when I see my grandchildren holding on to it and dealing with it every minute of every day, I wonder what's happening. Even the most conscientious parent cannot be sure that they're protecting their child. Would you comment on that particular note that you made in that description of the case?
Yes, so Senator, as you've sort of described the facts, it was a very difficult case. It was a young child. The defendant had ingratiated himself to the family to get access to the child, and so of course the family, when it came to light what the defendant had done with this child, felt tremendous guilt. And so obviously prosecuting it in the traditional sense was an important part of that case, but it was a very important part of that case to work with the family, to console the family, to help the family understand that it was not their fault, and to help the family see that the criminal justice system can do only so much. We can do what we did, which is prosecute and put the defendant in jail, but ultimately this child was young and the family was going to have to, figure out how to move forward. And I think part of that case that I am most proud of, is that I was able to help them sort of change that mindset from guilt to figuring out how are they going to move forward when the criminal justice system part of the case was over.
Thank you very much. Senator Graham?
Thank you. In that case, I think you.
Thank you, Chairman Blumenthal and Senator Hawley. And let me follow up with Senator Hawley's comments. I couldn't agree more. I could not agree more. And in the Senate Judiciary Committee, after some graphic hearings where parents and victims came forward and told us what had happened to them online, we decided to take action. We passed 6 bills related to this issue, child sexual abuse and similar issues, 6 bills. And something happened that was miraculous. All 6 passed unanimously. Every Democrat and every Republican. Take a look at the folks who are up on this end of the table. It's across the political spectrum. We all agreed on this. What has happened since? Nothing. 6 bills waiting for a day on the calendar, 6 bills waiting for a national debate, 6 bills passed unanimously on a bipartisan basis. And they put real teeth in enforcement, too. And I think that's why they've gone nowhere. Big tech is the big kid on the block when it comes to this issue and many other issues before us. That's a reality. I want to thank Chairman Blumenthal and Senator Hawley for bringing together so many members at this hearing. Our philosophy in putting together the subcommittees was to say to each of the senators in charge of them, do your best. Take your issue that means something to you and do your best to bring it to the American people and legislation to the floor of the United States Senate. This committee is one that I'm counting on to be successful in this regard. Mr. Behar, thank you for the courage of stepping up and speaking up. The only amendment I would make to the chairman's remarks and Senator Hawley's is it's not only a parent's issue, it's a grandparent's issue too. We see this and it scares the hell out of us. So thank you for what you brought us today. I'm particularly intrigued by your idea of a survey so that we find out from the source what's really happening. My experience at Capitol Hill goes back several years. I took on a tobacco issue. We were hitting our head against the wall trying to penetrate this vast lobby at the time. The one way we managed to penetrate it was to make it a children's issue, protecting kids from addiction to tobacco. And then a lot of good things started happening. Why is it that this issue, which relates to our kids so much more and is so much more dangerous even than tobacco in my estimation, why is it so difficult? Senator Hawley's correct. We're really fighting the biggest kid on the block when it comes to this issue. Thank you, Mr. Chairman. Judge, thank you very much. And we know the duration of the trip makes it a special sacrifice for you to be here, and we certainly appreciate you, your family, and friends who are in attendance for making that sacrifice. I'm going to start the round of questioning, 5 minutes for each member. Ms. Hill, most members of Congress who have tribal representation in their states understand this whole issue of tribal sovereignty and the fact that you could have served as Attorney General for the Cherokee Nation. Could you summarize in a few sentences the difference or the challenge that you faced with that responsibility?
Serving as Attorney General of the Cherokee Nation, is post-McGirt especially it's been very challenging. There's been a great increase in the number of criminal cases that are being heard. Indian tribes have jurisdiction over crimes committed by Indians across their Indian country. So throughout the reservation of the Cherokee Nation has jurisdiction, and the Office of the Attorney General is responsible for prosecuting those. So as the Attorney General, it has been the responsibility post-McGirt to scale up that office in a way that so we were able to handle all the different cases that came to us. And I think that that's something that for people who have Indian country in their districts are probably more familiar with that process and may not be that familiar to other people.
So your responsibility as a district court judge is separate and apart from the Cherokee Nation.
Certainly, a district court judge for the United States is an entirely different job than the job of an advocate. As Attorney General, of course, I was an advocate for the tribe's legal position and for its rights. Like all attorneys, I would advocate on behalf of my client with all the intellect and all of the strategic thought I could put into it on behalf of the nation. For a federal district judge, it's an entirely different job. The job is to look at all the cases that come before you impartially and fairly, and looking at everything on their own terms, and then applying the facts to the law. And it's a much different role entirely.
Thank you very much. Judge Manglonia, I want to pronounce your name correctly. Is it Manglonia?
Manglonia, yes, with the glottal.
Close now. You had a range of experience as a litigator and a jurist and spent your legal career in the Northern Mariana Islands, including a previous appointment to the bench to which you've been renominated. I want to make a note of this fact, that after the island was hit with devastating typhoons in 2015 and 2018, you kept the courthouse open to ensure the crucial work of the judiciary would not be interrupted. Your judicial chambers were awarded the 2019 Director's Award for Extraordinary Action from the Administrative Office of the U.S. Court. How have your experiences equipped you to continue serving that unique need in the Northern Marianas?
Senator, the two super typhoons that hit Saipan, with the distance to receiving the help, was truly challenging. I was very grateful for the support from the administrative office, as well as my neighboring district in Guam, as I mentioned. The experience that I've gone through made me stronger in regards to being creative in how to deal with challenges. And I actually, from our initial experience in 2015, some of the other districts that then suffered other natural disasters in other parts of the country were able to avail of some of the lessons that we learned. And I believe all this experience is going to ensure that should there be another disaster or calamity, I will be so well prepared to maintain or keep the courthouse doors open to ensure that people's constitutional rights are still addressed.
Well, congratulations to you on that effort.
Thank you.
Mr. Russell, while reviewing your record, I noticed you've been representing U.S. purchasers in a putative class action against the manufacturer of a breast cancer drug called Herceptin. The plaintiffs in the suit contend the company falsely labeled vials of the drug so that the purchasers regularly received less of the active ingredient than they thought they were receiving. Can you tell us about your work in that case and what specific claims the class is raising?
Senator, the plaintiffs in that case, it's a putative class action. It's also a multi-district litigation case. And the claims are breach of warranty, fraud. There are several different claims relating to the lack of Herceptin that is showing up in the vials over a historical period of time. And so the claims are that the doctors' offices having to administer the Herceptin were required to open additional vials at cost and loss in each time that they administered Herceptin to a breast cancer patient.
I'm a little familiar with that issue because we've had the opposite be the case as well, that drugs are put in containers far greater than necessary for the ordinary dosage, and many of these very expensive drugs end up being surplus and thrown away. So labeling and handling and bottling is a critical element in making sure that the American consumer is treated fairly. Thank you very much. Senator Graham?
Thank you. Yes.
Collecting data, identifying trends, developing strategies to prevent harm, reducing risk, sharing these practices, this is how you combat an epidemic. It's worked in the past. We use the same public health approach to dramatically cut automobile fatalities. We still drive where we need to go, but we have seatbelts and speed limits that help us get there alive. Public health experts are already working to address gun violence in real time. Last year, Congress passed the bipartisan Safer Communities Act. I want to salute my colleague, Senator Cornyn, who is here with us today, representing the minority. It took real courage, John. We may disagree on a lot of issues, but at a time when we needed to act, you did your best, and I thank you for that. It included $250 million in funding for community violence intervention and $250 million for states to provide comprehensive community mental health services. Let me give one example of the successful, innovative programs underway. In Chicago, I heard from doctors personally who were sick of treating gunshot victims on the operating table. They wanted to prevent the gruesome injuries from happening in the first place. So in 2018, I brought together the CEOs of the 10 largest hospitals serving Chicago to understand what they were doing in the neighborhoods surrounding their hospitals and how we can do more. We formed the Chicago HEAL Initiative, which has emerged as a national exemplar of how hospitals can collaborate and reach outside their walls to prevent gun violence. These hospitals have increased local hiring by 84% in the last 4 years. They've opened 24 school-based health clinics to serve 11,000 students and are training nearly 4,000 local students for careers in healthcare. Most importantly, these hospitals aren't just stitching up physical injuries. They're addressing the emotional scars of their patients. Through counseling and case management to prevent retaliation and promote successful recovery, just 2% of over 8,000 participating patients at the University of Chicago have returned to the hospital. Without these programs and this initiative, 45% of patients with a gunshot wound are likely to return within 5 years with another one. That is a stunning statistic. 45% within 5 years will return shot a second time. Similar steps are underway across the country to use this strategy, which is known as community violence intervention. CVI uses trusted community figures to engage with individuals at high risk of perpetrating or being victims of violence. They work to interrupt acts of violence before they happen and connect people with treatment and tools that decrease the risk of future violence. It's time for us to build on this bipartisan Safer Communities Act and ongoing efforts that are working in red and blue states. And join together, surely we can find some common ground between parties to create real change for the American people when it comes to this public health crisis of gun violence. I now turn to Senator Cornyn. Republican side, for the order that the members on your side will offer the amendments. He has already given me your name earlier, but I want to let you proceed.
Thank you, Mr. Chairman. If it's okay, Senator Blackburn, I think you have a couple of amendments. And as we get involved in this process, I just want to, when we did subpoenas of Crossfire Hurricane, one of the most corrupt investigations in the history of the country, can't remember, 16, 20 votes, can't remember what it was. So I'm glad we're having votes. I just want to remind the public who may still be watching this for some odd reason, this is going nowhere. This is a political exercise. And Mr. Chairman, I'm still dumbfounded that after voting a bill out of the committee that supposedly fixes this problem from your point of view, why we haven't brought it up to the floor. I mean, you have a solution, you say it was voted out of the committee and it's never been brought to the floor. You're doing an investigation to fix a problem that you've already had a legislative solution for. What are we, if you want to fix the problem, try to pass the bill that you claim fixes the problem. The reason we haven't voted on that bill, Mr. Chairman, and never will, is because there's just not the votes. This is incredibly, in my view, unconstitutional. So we'll play this game for a while. Nothing will happen. The subpoenas never get issued. The bill never gets voted on. But it's important enough to destroy the committee.
Senator Graham, would you yield to a question? No, I defer to Senator Cornyn.
We're in the amendment stage.
Would the senator yield for a question?
Just 1 second, please. We're in the amendment stage. What I'll say to my colleagues is we're going to finish this today. And Senator...
We're going to finish this bill today?
The amendments to the bill today. Senator Blackburn
Wow.
will be the first Republican you want recognized.
Thank you, Mr.
I was asked the senator to yield for a question while he had the floor.
Wait a minute,
if I'm
I
not
want to know,
mistaken.
like,
I'll
so
certainly defer to Senator Blackburn.
got 12 minutes to finish
I
this
think the
bill?
practice
Well-
here in the Senate is if senators has the floor and another senator asks them to yield to a question and they say, yes, I will, that
Go
then
ahead
that
to Senator
senator
Graham.
has the floor.
yes, you can definitely, well, one, are we going to be able to debate this bill? What happens? What's the game plan? What do you intend to do?
Of course, it's in your hands. 177 amendments are pending. That's not the first time we've had that number before the committee.
We said we're going to vote on it today.
I said we're going to finish
So
the
wait,
bill today.
what does today mean?
Today is
Today at noon?
Thursday.
Is that when we're going to vote on this bill? When are we going to vote on the bill today?
Stay here as long as you wish to offer amendments.
Okay, so we can waive the 2-hour rule.
No, I don't know that the 2-hour rule has been invoked, but you remember we went through this before with Vanita
Okay,
Gupta.
so basically, you're giving us today, which is Thursday. Wow, okay,
Would the senator yield for a question?
absolutely.
These are private citizens that the majority of the committee seeks to subpoena, correct? Senator Graham?
Yes.
Are you familiar with any legitimate legislative purpose for subpoenaing private citizens?
I think this is a charade politically motivated to attack the integrity of the Roberts Court, to act on what they said they wanted to do to destroy Clarence Thomas's reputation. I think if they really cared about the ethics practices of the court, we would be looking into Sotomayor's situation, Justice Sotomayor, where staff members apparently called people, you need to sell some books if she's going to speak. So, yeah, I think this is all politically motivated. I think the two private citizens involved, particularly Leonard Leo, is at the top of the guy I hate most list in the conservative world. I think this is despicable, what they're doing to these people. I think it's bad for the country. I think this is a joke simply because the bill to fix the problem they claim it exists, they won't even bring it up to the floor. So this is an investigation of private citizens, Senator Cornyn, that I think is politically motivated, not legislatively motivated, because if you wanted to pass legislation, you've already done it out of committee. All you got to do is bring it to the floor. You're in charge. So no, I think it's patently obvious. There's no legislative purpose. This is designed to get people they don't like and try to destroy Clarence Thomas.
If the senator will yield for one more question, we heard some discussion about precedent earlier. The chairman cited what he claimed to be a precedent. I'm not clear that that's actually the case, but in other words, that the rule's been violated before, and so now that sets a precedent for that action. It becomes the norm. So what limitation is there on the majority of the Judiciary Committee issuing subpoenas to private citizens for any purpose that they may please?
That's the heart
That's
of
the
the matter.
precedent that will be set, correctly?
Anybody we don't like, for whatever reason, we'll begin to subpoena on a partisan basis. The people I wanted to subpoena were involved in a corrupt investigation conducted by the Department of Justice called Crossfire Hurricane. The court rebuked, the FISA court rebuked the Department of Justice and FBI lawyers for misleading the court. Here, we have efforts to bring in two private citizens associated with Clarence Thomas. There is no effort to go after other situations involving judges that may have done something untoward. So what we're doing now is using this committee as sort of a political vendetta. You don't like a couple of people who are active on the other side, and we're going to subpoena you. Yeah, I really.
And that would be the precedent that would be set.
Yeah, I think so. And I didn't do that. Senator Grassley didn't do that. We actually worked together to issue subpoena for tech CEOs.
Senator Graham, would you yield for another question?
Yes, sir.
I would appreciate it if you and/or Senator Cornyn could educate me here on the so-called precedent of subpoenaing private citizens. Let me give you an example. I read recently where the FBI it has announced that it is prosecuting a prostitution ring here in Washington, and I understand it may be New York, or New Jersey. And the clients include prominent politicians and generals and lobbyists. And in order for the client to frequent this brothel, the client had to give his name, his address, his social security number, his credit card. Could we issue a subpoena for their names?
I'm sorry. Could you repeat it?
Do I have to repeat the whole thing?
No. I got the
You got the
prostitution
brothel
ring.
part, right?
Yeah, yeah. I was wondering
Okay.
if you said they were subpoenaing me. No.
No,
they're not. Yeah. Okay.
Under this precedent, will we be allowed to subpoena those names?
I don't know where we're going, I guess, Senator Kennedy. I know that the subpoenas were issued in the past that I'm aware of involving oversight function of an investigation by the Department of Justice. I know we've worked together to issue subpoenas to get people before the committee in the tech business who we think the companies in question are doing a lot of harm to the country. Leonard Leo and Harlan Crow are very prominent conservative people. And we're going after, you talk about Leonard Leo, like, where do you get your judges from? We get our judges from conservative people who make recommendations to us. I mean, where do you get your judges from? You have liberal groups, I'm sure, recommending names. This is really dangerous, Senator Kennedy. There are two individuals, one's been working committee for 4 months. They want to know anybody you ever saw that ever got on a plane you ever met at the gas station. It's beyond overbroad. It's chilling to me. I have literally begged my colleagues, please don't make me go down this road. Please don't make me have to fight back over this that is not going to advance any cause. You have picked political people you want to please over the smooth and efficient operation of the Judiciary Committee. You've made me and everybody on this side fight back because we believe what you're doing is politically motivated. There's not an ounce of legislative purpose in these subpoenas, because if you really gave a damn about legislation to fix the problem, you would bring the bill up to the floor that has passed this committee. So, yeah, this is really bad, Senator Kennedy. There is no limit to it. I hope you're satisfied over there.
Would the senator
Chair will reclaim the time. Chair reclaims the time. I'm sorry, Senator Kennedy.
But I have another question.
Well, I'm sure you have plenty of questions. I recognize Senator Graham to tell the order of Republicans offering amendments. I want to make one statement, and then we'll proceed to ask Senator
But it was
Blackburn.
a good question I had.
I'm sure it's good.
Mr. Chairman?
All your questions are good. Keep in mind, as we talk about the expanding the limit opportunity under subpoenas and whether we're going too far, we have named 2 individuals who we've worked with for months trying to secure this information. Let me tell you, 2 individuals, that's it, in the subpoenas so far. And I will tell you this too. Contrast that with the Republicans' unprecedented subpoena authorization in 2020 on Crossfire Hurricane. They provided the chair with a blanket authorization to subpoena more than 50 named persons and an unlimited number of unnamed persons. So the sanctity of the subpoena obviously was not the major consideration at that moment.
Can I ask you a question,
Senator
Mr.
Blackburn,
Chairman?
Senator Blackburn.
Would you yield for a question?
Well, wait a minute.
Senator Blackburn.
Senator Kennedy, Mr. Chairman, can I respond to what you said?
Of course.
Because I'm the one that sought the subpoenas.
Yes, it's true.
We were trying to find out how, in America, the FBI could use Christopher Steele's dossier that was full of lies and garbage to get warrants against American citizens. We're trying to find out how Crossfire Hurricane got off the rails to the point that the FISA court rebuked and issued sanctions against Department of Justice and FBI legal counsel for misrepresenting to the court the true nature of the facts. This is a political effort by the radical left to destroy this court. You have subpoenaed 2 prominent conservative people. You have ignored other problems with the court that Senator Blackburn would like to bring up to the committee. There's legislation you have passed before you did the subpoenas that would fix the problem. Why would you do the subpoenas after you pass legislation to fix the problem? You have chosen not to bring the legislation to the floor because it's unconstitutional. There is no legislative purpose here. This is politics, it's raw politics, it's dangerous politics, and this committee is taking the country down a very dark and dangerous road. That's the difference.
Will you yield for a question?
Yes.
First of all, Mr. Chairman, Mr. Ranking Member, isn't it true that the committee requested 25 years worth of documents from Mr. Crow, and Mr. Crow offered 5 years of those documents, notwithstanding the absence of a legislative purpose, notwithstanding the fact that he was under no obligation to do that?
That's correct.
Isn't it also true, Mr. Ranking Member, that on November 9th, 2023, what's that, 3 weeks ago, today, in this very hearing, our chairman, our committee chairman said from this very seat, quote, "It is within the power of the Chief Justice and his fellow justices to solve this problem before noon today, and they should have done so a long time ago." In other words, he was conditioning it upon the Supreme Court issuing its own code of conduct, which the Supreme Court has now done, which I haven't heard anyone describe as inadequate, insufficient. Wasn't that the entire condition precedent for this committee even considering that?
All I can say is this is not about the Supreme Court.
We stand. In the time that I've served on Judiciary Committee and in recent time, the Democrats have never invoked the 2-hour rule on this committee. Never. So that we were able to continue our business and finish it. Now, for the second time, as my chairmanship, the Republicans have invoked the 2-hour rule as they did on the Vanita Gupta nomination, which means that we literally have until 12 o'clock to complete our business.
No, we have next week, and we have the week after that, and we have the week after that. What is the urgency here? Give me a break. You got a bill on the floor.
Senator Graham, would you yield to a question?
Please let me finish.
The chair has the floor. We will therefore proceed with a vote on the chair's November 2nd, 2023 motion to authorize subpoenas relating to the committee's Supreme Court ethics investigation. The clerk will call the roll.
I have a point of order, Mr. Chairman. I have a point of order. The chair shall entertain, okay, excuse me. I raise a point of order.
Please proceed.
By limiting, can I raise a point of order? Mr. Chairman, can I please raise a point of order as to what you're doing?
We're on a roll call.
I have a right under Rule 4 to have a roll call vote to end debate. That's in the rule. I'm invoking that now.
In the middle of the roll.
Yes.
Are you denying me the right to vote to end debate under Rule 4?
Clerk will suspend. The chair makes a motion to suspend Rule 4. Clerk will call the roll.
I object. I asked a roll call vote, please.
Yes, we'll roll call.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Suspending Rule 4.
So that we can complete the vote.
Mr. Blumenthal. Ms. Arona. Mr. Booker.
This is a vote to end debate, right?
Right.
Mr. Ossoff.
Thank you.
Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No by proxy.
Mr. Cornyn. Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Hawley. Mr. Cotton. Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
Mr. Chairman, Senator Grassley did not give me his proxy. I had bad information. Thank you.
The nays are 1.
The question now is on the proceeding to vote on the chair's November 2nd, 2023 motion to authorize subpoenas. The clerk will call the roll.
Mr. Chairman, can I raise a point of order, please?
I'm
May I?
sorry, but we have to proceed with this roll call.
I can't raise a point of order before we vote.
Clerk will call the roll.
Mr. Whitehouse.
Aye.
Go away, go away.
Ms. Klobuchar. Mr. Coons.
You should just leave it.
Mr. Coons. Mr. Blumenthal. Ms. Arona. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler.
The motion is agreed to. The chair is authorized to issue subpoenas pursuant to the motion, and the committee stands adjourned. The clerk will call the roll.
Mr. Chairman, are we going to have an opportunity to speak on the nominees?
Yes, we're going to, oh, I'm sorry. We already had done that at great length.
Well, I think this deserves some commentary, given the nature of the nominee, and I'd like to ask to speak on the nomination.
Senator, we've debated these two nominees twice.
Mr. Chairman, I would also like to speak on the nomination.
I understand what you'd like to do, but I'm saying that in fairness, we have debated these nominees twice, and I ask the clerk to call the roll.
Mr. Chairman,
Mr.
you're
Chairman.
denying us an opportunity to speak on a nominee?
I mean,
Third time, no.
okay, do this. Just
We don't
do
have a
it.
right to speak under the rules?
Under the third time, I'd say no.
So you're just going to make it up?
So, yeah.
I'd like to
There's going to be a lot of
to-
consequences
I'd like
coming
to
here.
speak too, Mr.
You're going to have a lot of consequences coming if you go down this road.
You better
I've
believe
cautioned
it.
you. I've cautioned a lot of you.
The clerk will call the roll.
Listen to me. I've cautioned a lot of you.
Mr. Chairman.
Mr. Chairman, don't we get the opportunity to speak?
We're in a roll call.
So you're telling us to shut up?
Even though multiple
You
members
want
have
us
asked to
to
speak?
shut up? Is that what you're saying?
A lot of people didn't speak on the two nominees before.
We've done.
Would you raise your hand if you did not speak?
I did not have a.
Senator Corn didn't even have a chance to speak.
Senator Blackburn had a chance to speak.
We've got several folks, Mr. Chairman, who didn't have a chance to speak.
We want to tell you again why these nominees are awful.
Or in Senator Corn's case, tell you for the first time. You're just going to sit there and ignore us?
Senator Blackburn, have you spoken on these nominees?
I've not had the
you like
opportunity to
to?
speak. I would like very much to speak on Mr.
Mr. Chairman,
Casaby.
I urge you to let Senator Blackburn speak.
Senator Corn as well. Senator Corn hasn't had a chance to speak.
That's correct. Point of order, Mr. Chairman. You can't limit debate without invoking Rule 4. You haven't done that.
We have debated.
We've debated on prior occasions when we didn't have a quorum. That vote didn't count. We've got people who are here now who weren't here then who would like to speak.
Can we speak on the other nominees?
Or is your plan just to end all debate today? Is your plan to end all debate? Do you have an answer? You're going to rely on someone whispering in your ear. What's your plan?
No.
No, we're not. Okay, listen, here's the deal. We worked 7 weeks to try to solution the asylum problems. You boycotted the committee.
Mr. Chairman, I don't know if you've left us any alternative but to deny the committee a quorum. I think that's something we ought to seriously consider.
tell you what,
Mr. Cotton says the chairman needs to rethink his decision and let Senator Corn and Senator Blackburn speak. That's what Mr. Cotton says. You can mark that down as my vote.
Yeah,
And everybody over there who's not willing to look at me or look at Dick Durbin needs to think about it as well. Mr. Kennedy wants to speak as well. Mark Mr. Cotton down saying Mr. Kennedy needs to speak too.
I'm waiting to be heard on the nominee. I've requested several times to be heard on the nominee.
So no, I guess Senator Durbin is not going to allow women to speak either. I thought that was sacrosanct in your party.
Aye. The nomination be favorably reported to the floor. Up next is Judge Yumi Lee, nominated to the U.S. District Court for the...
Mr. Chairman,
who has not been allowed to speak on that nominee?
Mr. Chairman, you just destroyed
Yeah.
one of the most important committees in the United States Senate.
Chair would note,
And you set a precedent,
the chair
which
would
will
note-
be repeated every time one party or the other takes advantage and takes the low road.
Chair will note
It
that
sets a
both nominees
precedent
have
that
been
will then
debated twice.
become the norm.
Kashibai and
Congratulations on destroying the United States Senate Judiciary Committee.
Up next is Judge Yumi Lee, nominated to the U.S. District Court for the Northern
Who
District
has
of
not
California.
spoken on this nominee?
Clerk will call the roll.
Will you raise your hand? Look at all these people who have never said a word before you make them vote. Never said a word before you make them vote.
Just going along with it. Just going along with it.
You know, when
Mr.
we were in
Coons
the
said he would
majority,
allow members to speak.
Mr. Chairman, when we were in the majority, we allowed Democrats to speak ad nauseum, at great length. We never did this.
Both of these nominees have had 2 opportunities for speeches by members.
Mr., you have to bring them up again. It wasn't our fault, it's your fault.
Going right along with it.
Mr. Chairman, I hope you're proud of yourself.
Is this guy talking to Dick Durbin, the chairman?
Yeah, you really have. I don't know what drives this, Dick. I really don't.
Mr. Chairman, is it you driving it, or is it your staff
Yeah, is
driving
Joe
it?
Zogby the chairman of this committee, or is it
House
you?
driving this? This is completely inappropriate not to let us be heard on these nominations, and you know that.
Your own members have told you to let them speak.
This is a complete disgrace.
Maybe you can share
I
with us.
see my colleagues over here who understand what goes around comes around.
I mean, this is so unnecessary to ruin the committee over a political exercise that's going nowhere. Senator Whitehouse.
I would like to, was my name called? I can't hear. Where's that voice?
Was he recognized to speak?
We're on a roll call.
Ma'am? I'd like to speak, please.
We're on a roll call.
I'm waiting to be heard on the nominations. Is this an illegal vote?
So now Joe Zogby is going to dictate to other senators how they're going to vote?
On this vote, the ayes are 10.
The nomination will be favorably reported. We now turn to nominations that have not been debated before the committee, and the committee